Oops. Welcome back, everyone. Second day of Education Committee. Looks like we've got a few smiling faces here and some that are just here. And that's all I'm going to say about that. Anyway, a few housekeeping items again this morning. Just want to mention with these working groups, we assigned 3 of them yesterday. And we've talked to, I believe the good co-chair is going to, he's going to be the chairman for 2 of those, and then Senator Rothfuss will be the chair for the other one. I just wanted to mention, and actually Tanya sent out an email to you just to kind of explain who's on them thus far. I guess Representative Strzok would like to be on one of them, so just, we'll add you to the list, and Chairman, I always want to say Chairman Ocean, because it's such a neat name. Chairman Andrew will get with you. But the big thing that was mentioned, and the reason that I'm not asking to host, or excuse me, to chair any of them, is I'm going to be gone for about 2.5 weeks in September. And our deadline to have the ideas in for drafting instructions to LSO is September 19th. And so that's why we've kind of put it on these folks right here. So those of you that are going to be chairing those committees, get with your committees. If there's other people that want to volunteer with those, as well as some of the stakeholders in the room from yesterday, please contact either Senator Rothfuss or the good co-chair and let them know that you're interested in serving on those working groups. And we'll try to get those drafting instructions to LSO in a timely manner. So anything else on that, LSO, that we need to talk about?
No, Madam Chairwoman, unless you want to just run through those bill drafts quickly. 26 LSO 94 is the Hathaway lump sum bill, and that has a working group assigned to it. 26 LSO 0096 is the use of the Hathaway Scholarship at private institutions. That has a working group associated with it. 2692 Reading Assessment and Interventions, that has a working group associated with it. And then there are 4 new drafts. One is the Literacy Division with the positions in WDE, and those numbers are to be provided by the Department of Education. A new draft on charter schools, which you heard about yesterday, late in the day. And then a new draft on the Hathaway, changing it from and to or. And then the final new draft is on the increase for the Hathaway. For honors, that amount will be $5,360. Performance will be $4,020. And the provisional and opportunity will be $2,680. And those instructions were provided by Representative Lawley. And then you sponsored 26 LSO 95, Wyoming Tomorrow Scholarship Program amendments, and then 26 LSO 0093 K-12 Public School Charter School amendments was not moved forward by the committee. So just thought it would be helpful to kind of summarize the actions from yesterday and make sure all the committee members are aware of where we're at.
Perfect, and that is in the email that Tanya sent out to you, so be sure and check your emails. And thank you for that. Anything else? No? Okay. So today we did, we think the good co-chair was worried about our time as we went yesterday a little bit over. We're hoping not to today, but we do have a potential for a lunch break if we go into a lot of detail, and these bills today may require that we have a lunch break, but they may require that we can get through them in a timely manner and not need the lunch break. So we're just going to kind of play it by ear. Is that okay, Co-Chair? And go from there. So with that, unless there's anything else from the committee or LSO, we'll go ahead and get started. We're going to start with 26 LSO 0088 K through 12 Public School Discipline.
Madam Chairman, did you want to call roll this morning?
Oh, yeah, we can call roll again. That's a great idea. Well, let's do it.
Thank you. So for August 22nd, 2025, Joint Education, Senator Brennan. Here. Senator Olson. Here. Senator Rothfuss. Here. Senator Scott. Here. Representative Bratton. Here. Representative Erickson.
Here.
Representative Gugemas. Here. Representative Kelly.
Here.
Representative Lawley.
Here.
Representative Singh.
Here.
Representative Strock,
Here.
Representative Williams,
Here.
Co-Chairman Andrew,
Here.
and Co-Chairwoman Schuler.
Here.
You have a quorum.
Thank you so much. And it's even on the program call to order, and I've eaten today, so there's no excuses for me not to be on top of things. So, all right, we'll turn the time over to Tanya, and she can tell us a little bit about 88.
Madam Chairwoman, members of the committee, again, Tanya Heitrick, Operations Administrator for the Legislative Service Office. Recall at your last meeting, you requested two bills that are sort of interrelated. And it would note the drafting instructions were to basically, whatever didn't fit in one, put it in the other draft, but that is not possible. The drafting instructions from Chairman Andrew versus the drafting instructions from the WA, one, were somewhat inconsistent in areas, and then two, the areas that were consistent were stated differently, and there were a bit of variances. So LSO drafted two bills. You can consider both of those and decide which concepts you'd like to go with, or perhaps sponsor both bills. And with that, I'll go ahead and walk 26 LSO 0088. That's the K-12 public school discipline. These instructions came from Chairman Andrew. Of course, if you have any sort of substantive questions about the policies contained therein, I would defer to him for those. We did utilize LSO's drafting and guidelines and best practices in drafting this, and in instances, where we could make the language consistent, we went ahead and did that. The drafting, establish this bill high level, this bill high level establishes requirements for student punishment and discipline. It eliminates the ability of school districts to withhold diplomas. It modifies the civil and criminal immunity for school districts. And then there are a number of conforming amendments. Like the other drafts that have been presented, there are policy choices for you all to make. Those are outlined in staff comments throughout the bill. I'll note those as I go through it. Section 1 begins on page 2, line 18. This is amending existing statutes. And as you all know, not the entire statutes are brought in. It's only those provisions that are amended. There are, many existing statutes that we did not amend that that are not contained in the bill draft. Page 2, lines 22 through 28 amends 21-2-304A. This creates a new provision requiring the state superintendent to adopt rules for the use of reasonable force for school district employees to remove students. And that provision or that authority is contained elsewhere in the bill. Moving on, there were extensive amendments. Oh,
Question? Yes, go ahead, Senator Scott.
Mr. Chairman, I thought I heard her say state superintendent, and it says State Board of Education. What's the intention?
Yes, I apologize, Madam Chairwoman. It is State Board. Thank you, Senator Scott, for correcting me. Moving on to 21-4-308, that governs punishment and disciplinary measures currently in statutes. As I said, there are extensive amendments. The first is that it removes the permissive ability for school districts. It now commands them to adopt these policies or rules, and it requires them, I guess that's it. They're just changing the permissive to mandatory. And then paragraph 1 on page 3, lines 15 through page 4, line 16. This provides all school districts with authority to discipline students under the supervision of employees, and that includes school principals, the principal's designated representative, and that is to ensure that all students have the opportunity to learn on school district property. And for this purpose, school district property means, and this is on page 4, lines 1 through 6, School district property means any property owned or leased by a school district, including classrooms, property where any school district or school-sponsored activities take place, as defined by 21.3.137A Romanet 5, regardless of location and transportation to or from school-sponsored activities. Paragraph 2 on page 4, beginning on line 8 through page 6, line 12, identifies the actions of school district employees that they may take to maintain order in the classrooms. That includes enforcing classroom management rules, enforcing consequences. It also allows teachers to remove disobedient, disrespectful, violent, abusive, uncontrollable, or disruptive students using reasonable force. And that sort of goes back to the state board's authority to enact those rules. Those students will be referred to the principal, the school district superintendent, or the board of trustees for imposition of punishments.
Yes, go ahead, Senator.
Can I ask a question about this language, just the structure of the language where it says all school district employees seem to unilaterally have this authority statutorily based on the construction, as I read it. Now, it does talk about creating some policies up above, and this is the Board of Trustees is trying to create policies, but it has the policies shall. So does that mean literally any employee of the school district that's doing anything, and I'm just going to arbitrarily pick, I don't know, a school lunch monitor or something like that, has all the same authorities as the principal through these policies? That seems like it's the construct based on the shalls. I don't know if that's the intent, but that's the way I'm reading it.
Madam Chairwoman and Senator Rothfuss, I do believe that was the drafting instructions, and I think your interpretation of the employees is accurate. It's all school district employees have this authority.
Okay, so for example, Madam Chairman, even the business manager that doesn't deal with students is a school district employee and therefore would have full authority to remove a child from a school district property. Is that
Madam
accurate?
Chairwoman,
Okay.
Senator Rothfuss, that's an accurate interpretation. And I would point out that's one distinction between 26 LSO 0088 and 26 LSO 0091.
Gotcha.
There's a bit of a difference, policy choice there.
Great, thank you.
Moving on to subdivision, subdivision 2 on page 5, beginning on line 15 through page 6, line 12. This requires that the removing person or the Board of Trustees or the school district superintendent, whoever's imposing those consequences on the student, confers with the teacher that has removed the student from the classroom, or rather the employee that has removed the student from the classroom, to Senator Rothfuss's point. Consequences and punishments imposed by the school principal or school district superintendent or the Board of Trustees. There's a list there of those punishments, and those begin on page 6, line 19, and run through page 7, line 15. And those include the student cannot go back to the classroom in which it was removed. They can go to an alternative classroom. It could be in-school suspension, dropout prevention measures, and suspension and expulsion in accordance with 21.4, 305, and 306. And it would note the drafting instructions didn't refer to 21.4, 305, and 306, but those are the provisions that outline the due process associated with removal of a student in those instances. There's notice, opportunity to defend yourself, and certain timelines that are associated with that as well. Those students that are removed for 10 days or less, the process is different than those students that are removed in excess of 10 days. And it would note, LSO prepared a memo at the May meeting that covered in-school or suspension, expulsion, punishments, and seclusion and restraint, which dovetails into the use of reasonable force to remove a child. I don't know if those are the same things or if they differ, but there are provisions that require rules or guidance on seclusion and restraint. Subsection E on the bottom of page 7, this mandates that school employees will receive assistance from the principal in removing the student. Subsection F on page 8, lines 2 through 6, requires school districts to provide training to improve classroom management, violence prevention, conflict resolution, and areas related to student discipline. Subsection G, created on page 8, lines 8 through 11, this authority gives the school district authority to refer the student to the district attorney to initiate legal proceedings for criminal conduct that occurs on school property. And you'll note the staff comment on page 8, lines 15 through 23. The district attorney already has this authority in the event that a criminal act is performed on school property. He or she already has this authority, and the fact that now it requires referral could create some confusion. And so perhaps it's notice to the district attorney of those. But I just wanted to mention that. They don't need the referral to take action. I guess that's the main point. Moving on, page 8, line 27 through page 9, line 8. This creates subsection 8, which requires mandatory reporting. It requires the school principal and the school district superintendent to defend and support the actions of the reporting employee, and gives criminal and civil immunity to employees that make a good faith report. You'll note on page 9, lines 11 through 24, again, there's a staff comment related to 308H. These employees are covered by the Governmental Claims Act, which is Wyoming Statute 1-39-101 through 1-39-124. And so any public employee acting in the scope of his duties is covered by the Governmental Claims Act. And it may cause confusion in the application of sovereign immunity and the Governmental Claims Act with this language. And I recognize there's something similar in statute now, but something for the committee to consider, certainly.
Yes, question? Go ahead, Senator Scott.
Question on this particular point. And we've got several of these, as I believe, going through these drafts. Yeah, these statutes are going to be what the school district people look to, because they're in the education code. And they're not going to be familiar with the Governmental Claims Act. Would it be wise to put language like this in there with a cross-reference to the Governmental Claims Act, saying as provided in WS thus and such, referring to the Governmental Claims Act, and deal with it that way, so it's clear that that's governing, but we are repeating it here so that the school people will be well aware of that. It seems to me there's some virtue in doing it that way if we can draft it properly.
Yeah, Madam Chairwoman, Senator Scott, that's certainly an option in the event that that's the choice of the committee. I would recommend streamlining this and just referring to the Governmental Claims Act as provided by the Governmental Claims Act. The employee shall have, protections under that, rather than sort of calling out a separate and distinct perhaps differing interpretation of the Governmental Claims Act. That's certainly an option. It wasn't contained in the drafting instructions, but definitely a policy consideration for this committee. Does that respond to your question, Senator Scott?
Yeah, Madam Chairman, I think frankly, that's the way we ought to go, because I don't think we want to trespass on the Governmental Claims Act here and get something that some lawyer might get construed as different and cause a lot of confusion. But I do think we need to have enough for reference so that the employees understand there is protection. Otherwise, this is the part of the law they're going to be familiar with, if they're familiar with any part of it. And so I think there's a great virtue in having enough so they understand they are protected, but we don't want to change the Governmental Claims Act in the process of this.
Any other questions? Well,
Okay, moving on.
Proceed.
Page 9, lines 28 through 31. This creates subsection G. It requires the school district board of trustees to take reasonable steps to ensure the safety of students and school district employees when physical violence is likely to occur on school property. And as I stated on page 10, lines 1 through 15, this just outlines those statutes that were contained in that memo that we prepared. And there are potential overlap or inconsistencies with the specific language in those statutes versus what's contained in this bill. I would recommend sort of doing a crosswalk and making some policy decisions on which provision you'd like to use. And then finally, on page 10, line 19, there are two repealers, 21-4, 308B and C, and those are noted on the bottom of page 10. The first is the civil and criminal liability in the exercise of reasonable corporal discipline. That was a specific directive of the committee, not contained in the bill drafting instructions, but it was directed by the committee in May. And then the second directive was a repeal of retaining I guess, holding back a diploma or credit or course completed successfully in the event that a student owes a fee to the school district. And then lastly, section 3 on page 11, lines 3 through 5. This requires that the policies for the school districts are adopted no later than August 1st of 2026. That date is certainly something that could be changed by the committee. I don't know that there's any sort of magic with it. And then I guess lastly, this really is the last one. I think I've said that 3 times now. But page 11, lines 18 through 21, section 4 provides that this bill is effective immediately. And the purpose of that is because, one, this is a substantial deviation from current policy, and 2, because of section 3, which requires the policies to be adopted by August 1st of 2026. And it also allows the state board to move on their policies as well. So subject to your questions, Madam Chair and members of the committee.
questions for Tanya? Senator Scott?
On the effective date, I get nervous about an immediate effective date that's going to affect large numbers of members of the public and that sort of thing. But I see the need for preparation for that. It seems to me should structure, it used to be, we just put an effective date and that was in the future, like say July 1st, or which would be away from the start of a school year and a standard date, and agencies would start preparing the implementation well ahead of that. And somehow there's been an interpretation that they can't do that. Can we modify the effective date what's the best way to modify the effective date? Should we go to July 1st? Or should we have July 1st except for, say, preparation of rules or something like that? What's the current best practice?
Madam Chair, Senator Scott, that's a policy decision for you all. I think both are appropriate courses of action. If you'd like to delay the effective date to 2027 and then allow sort of a split effective date for rulemaking, that's certainly an option. I don't see that once the act is effective, if it were effective immediately, and the due dates contained in the bill draft are delayed by specific statement, August 1st, June 30th, whatever those dates are, that would give the agencies authority to proceed with that work with the effective date of the bill, which would be, March or early April.
Yes, go ahead, follow up.
Yes, I don't think going to 2027 would be wise, but going to July 1st, 2026 would mean that these substantive provisions would go in effect when school was out of session. So the old school year would be under the current policy, and then the next school year would be under the new policy. And I think that's the kind of effective date we really need on the substance of this.
Madam Chair, I think that's
Yes.
a policy decision for you all. And the one thing I would point out with that is if it is July 1st of 2026, they will not have the authority to enact those rules. They will not have the authority to enact those rules before July 1st of 2026. So in the event that you would like them to have authority to enact the rules and begin the work, you have two options. One, effective immediately with the specific dates for each one of those deliverables, which is how the bill draft is structured currently, or two, split effective dates. One is effective immediately for the rules and regulations, and two, a July 1st date for the substantive provisions. Those are the two options.
Other comments or questions? Okay. No other questions on this bill? Okay.
And Madam Chairwoman, I don't know if your preference is to take public comment on this bill now, or if you'd like to move to 91 and take public comment on both, because they're interrelated.
I was going to ask the committee that. I'm hearing, let's go ahead and do 91 and then we'll take, yeah, absolutely.
That's perfect. It gets me off the hot seat,
There you
so.
go. Get you off the hot seat quicker.
Moving on to 26 LSO 0091, Working Draft 06. This is the K-12 Public School Teacher Bill of Rights. These instructions came from the WEA with consultation with a number of individuals. I think that's listed on page 2 in the staff comments, lines 3 through 25. Again, substantively, these sort of overlap. I'm not going to rehash that, but I did note that earlier in my presentation. Page 2, line 29, this creates a new statute rather than amending the school disciplinary provisions. And so it creates a new chapter or Article 8 within Chapter 7, which is the chapter that governs teachers. And so the first portion of the bill contained in Wyoming Statute 217801, contained on page 2, lines 35 through page 3, line 21, provide the short title and sort of specifies the purpose. The one thing I would note about lines 5 through 21 on page 3, and this is outlined on the staff comment on page 4, is these are very similar to legislative findings. And there's a note there about the court's interpretation of legislative findings and the case law involving those. You do see them in statutes. I researched this a little bit in preparing this bill, but it is uncommon, and I'm not sure how a court would interpret those and whether they're really persuasive to a court. Page 5, line 2 through page 8, line 24, this creates the definitions that are applicable in the act. And so classroom, you can go ahead and take a look at that, but it's somewhat akin to the bill, to the provisions in 88. It's larger than just sort of the classroom space as you might traditionally think of it. And then it defines discipline, dialogue, objective disruptive behavior on the bottom of page 5. And it would note that objective disruptive behavior was not actually contained in the drafting instructions. It wasn't utilized in any provision of the drafting instructions, but LSO interpreted that to mean the basis for removal of a child. And so we sort of restructured that in a way we thought it made sense for organization, but perhaps the WEA has comments on that.
Yes, go ahead, Senator.
Question. On page 5, lines 14 through 19, am I reading this correctly that the way this is worded, to have one of these dialogues, you have to have all these parties, and if, say, the school principal was absent, or you didn't have a school counselor, you couldn't proceed. Is that a correct reading of the way this is written?
Madam Chair, Senator Scott, yes, that's an appropriate interpretation. And again, the drafting instructions were provided by WEA, and that's probably a better question to pose to them. There is discussion about the discipline dialogue later in the bill, and so I'm happy to kind of get to that and discuss it in due course if that works for you.
Okay,
Okay.
proceed.
Moving on to page 7, line 19. This is a progressive intervention system, and it would note disciplinary matrix is not defined in the bill. And it might be a consideration for the committee to define that. Perhaps it's a term of art that I'm just not familiar with, and all school district employees know what that means. But certainly, I don't know what that is. I don't work in that field. And then again, staff is any school district employee not included in the definition of teacher, which comes later. And there is a distinction, Senator Rothfuss, to your point, in this bill versus the other bill, which is all school district employees. And again, that's a policy choice for you all to make. On the bottom of page 7, again, subjective disruptive behavior is not utilized in the bill draft or in the bill drafting instructions. And I couldn't find a means to include it. So again, perhaps a question for WEA about how that dovetails into the directives in the bill.
I think Senator Scott has another question.
Madam Chairman, does that relate to the language that on the top of page 6, lines 1 and 2, does not require personal judgment based on personal feelings? I'm feeling it does, but I don't understand what the provision on the top of page 6 really means.
Madam Chair, Senator Scott, again, that is language that was provided by the WEA, and I would note that on lines 1 through 5 relates to objective disruptive behavior, which is on page 5, Romanet 3, and the provision on the bottom of page 7, I presume, is sort of the opposite of that. One is objective, it can be measured, it's, uniform and equitable, and subjective is sort of what your thoughts are. So I can't answer what A is intended to cover. I would suggest asking the Wyoming Education Association that question.
Follow up, go ahead.
And I would also, Madam Chairman, like to serve notice on the WA when they come up. My thought is we ought to, if we're going to work this bill, we ought to add anything that's a criminal offense under the Wyoming statutes as being objective behavior that would cause discipline.
Yes, go ahead, Representative.
Thank you, Madam Chairman. Tanya, I'm kind of going backwards a little bit here because I've been mulling this over as we've been moving through, but on page 5, the definition of classroom, because it seems like this is kind of operative in terms of other parts of the bill in the classroom. So what I don't interpret this to mean is restrooms, cafeteria, things like that. If you read this, depending on how you want to read this definition of classroom, so is that your understanding? Is it the bill doesn't really cover places like what happens in in the school lunchroom, what happens in a restroom, which we know can be flashpoints in a school. So I can't quite figure out the pulling out of the definition of the classroom unless there's a distinction being made. But I've kind of gone through here and I don't really see anything other than where we turn over here and it says, on page 9, classroom shall be free from, and how, like, is this bill really just about what happens in the classroom? I guess that's what I'm trying to understand.
Tanya?
Madam Chair and Representative Lawley, I think to a certain degree, I would agree with you that's the intent of the bill. It's where it's being utilized for instruction, regardless of the formal designation, and it includes space owned or leased by the school district where students enrolled are present and engaged in the educational process. So, perhaps a field trip or something along those lines would be included, but your example of a restroom, I don't think that would be present in this. In 88, there's a larger definition of the spaces included. It's all-inclusive, basically anywhere on the school property, any activity that's sponsored by the school. And so those are sort of the distinctions between the two bills, which made it very difficult to try to combine them. And it would note that if you look at page 8, and I'm skipping ahead here a bit, but lines 21 through 24, it's relevant to this discussion, is teaching and learning environment. And I don't know in the drafting what the difference is between a classroom as defined and a teaching and learning environment. So that's perhaps a question again for the Wyoming Education Association.
Right. Thank you. Thank you. That's
Please continue. You didn't have a follow-up, did you?
No, thank you.
Okay, go ahead.
Back to the definition of subjective disruptive behavior, I would note also on page 8, the first line is violation, page 8, line 1. And I am unclear of what a violation means. Perhaps it is the criminal conduct, but it may be fruitful for the committee to consider modifying or defining what a violation is under this act. Teacher is on page 8, lines 17 through 19. That's broader than just a certified teacher. It includes para or other staff engaged in the educational process. And in some instances in this bill, it's staff and teachers. And in other instances, there is a distinguishment between staff and teachers, and I'll get to that in a bit. I've already discussed the teaching and learning environment, so I'll go ahead and skip over that. Page 9, line 6 creates 217803. This articulates mandates relevant to the operation of schools and requires training to respond to safety threats. That last provision on page 9, subsection C, lines 16 through 18. There are 3 different provisions in this bill that talk about training for teachers or professional development. Some of them are a bit inconsistent or broader. it may be helpful to the committee to identify what the professional development includes in one place consistently. And I have noted on the bottom of page 9 and in every other instance that professional development is required where those occur in the bill. But I won't mention that comment again. Page 10, line 6 creates 217804. Romanet 1, lines 12 through 20, establish that the classroom teacher or the teacher and staff have the ability to establish and enforce classroom rules in the delivery of curriculum and instruments. The one question that we had in drafting this bill on page 10, line 17, is what instruments are included. I'm not familiar, perhaps, again, that's a term of art, but I would ask the WEA, is that necessary or duplicative? Line 11 is paragraph 2, page 11, lines 2 through 5 is paragraph 2. This requires prompt administrative support when the student poses a threat to the physical, emotional, psychological safety or well-being of students, teachers, or staff. Similar to the bill we just discussed. And then again, Romanet 3, this is another training and protocols section to respond to safety threats. And then we sort of get into the due process with the remaining provisions of the statute. Page 11, line 22, paragraph 4. This allows teachers and staff involved with students in their classroom to have access to inclusion in the behavior intervention planning during the discipline dialogue, which was a question of Senator Scott previously, and an opportunity to provide input regarding those consequences. Romanet 5, contained on page 12, lines 14 through 21, requires clear and consistent school disciplinary policies that are communicated to staff and equitably and consistently enforced. It also requires that in the adoption of those policies, the opportunity for public comment, which specifically includes parents and guardians. Page 12, lines 15 through 21, which is subsection 6, requires that ongoing, high-quality, and district-funded professional development is provided. Again, I noted those previous sections. Subsection 7 on page 13, lines 14 through 20, requires a minimum of 1 planning period for every teacher that has students enrolled in the class. And in the event a teacher agrees to something else, that needs to be in writing. And also, if there is a labor association like the Wyoming Education Association involved, they are to be included in those discussions. Paragraph 8 on lines 22 through 26 requires teachers and staff have the opportunity to be represented on boards and groups with authority to make decisions about modifying the curriculum, student disciplinary policies and procedures or school schedules. And I know Mr. Mullen talked to this yesterday, that in other states, there are non-voting or ex officio members on the district board, but the staff comment on page 13 that goes on to page 14 sort of outlines what that process might look like. It needs to be clearly identified. I don't think you could vote a member of a school district onto a board without them running through the appropriate process for that. Page 14, line 10, creates 21-7805. Subsection A allows for the immediate removal of a student from a classroom by the classroom teacher. So this is a distinction between 88 and 91. And then teachers have to create a classroom management plan prior to the commencement of every school year, has to include multi-tiered system of supports, and it has to be submitted to various officials in the school district. That's in subsection B on lines 17 through 24. Subsection C provides that upon the removal of a student pursuant to subsection A, the student shall be placed in the immediate control of the school principal, the principal's designee, or a school behavioral specialist if one is employed by the school. For the remainder of the school day, that student is excluded from the classroom, sent home if adult supervision is present, or placed in another classroom. And in the discipline of the student, it's required that it aligns with the classroom management plan that's required pursuant to subsection B. It also requires that the school principal provide written and telephonic notice to, or telephonic notice to the student's parents or guardian. Page 15, lines 15 through 21, provides that the student may be readmitted to the teacher's classroom from which they were removed with written notice from the principal's designee, or the behavioral specialist if one is employed by the school. And those provisions are sort of duplicative in other places. The authority granted to the principal is also granted to his designee, his or her designee, or a behavioral specialist if employed. Not all school districts have those. And so that notice is required to the teacher that removes the student. Subsection E on page 16 provides that any student removed from the classroom by a classroom teacher, these are sort of the ultimate penalties, I guess, for repeated disruptive behavior. And Romanet I, in the event the student is removed 3 times or more in 30 calendar days, they shall receive in-school suspension or may require the students attend another school in the school district. So the first 2 consequences are mandatory. The third consequence of referring the student to another school is permissive. And in this instance, I think I referenced this previously. I know I referenced it in the last bill draft, but the memo dated May 13th provided to this committee is relevant to this bill draft. If you have the electronic copy, that blue language, you can just click on it and it will take you to the memo. Moving on to page 16, line 33 on to page 17, line 9. Again, this is, I guess, the maximum penalty if a student is removed 10 or more times in any one semester and all other reasonable means of classroom discipline have been exhausted. They cannot return to the classroom from which they were removed unless, again, the discipline dialogue, which Senator Scott referred to earlier, is complete and a behavior plan is created. And again, it must be agreed upon by the student, the student's parents, the classroom teacher, the school counselor, and the principal. The behavioral plan must reflect best practices and must be age appropriate and may include providing support to the parent or the student in the form of counseling, home visits, or appropriate classes. Subsection F on lines 11 through 21. If the student continues disruptive behavior after readmission under subsection D, which is not E, but on the prior page, upon the request of the teacher that removed the student, the principal has the authority to, again, impose maximum consequences and punishment authorized by the Student Code of Conduct and those that are consistent with the progressive intervention system. Again, the teacher or the principal has to inform the parents of what those consequences are. Subsection G, page 8, lines 1 through 7, charges each school district with the adoption of an appeal process to allow a teacher to challenge the action of a principal if the principal fails to remove the student or the teacher feels that the student was readmitted to the classroom prematurely. 217806, created on page 18, line 9, subsection A on lines 11 through 14, provide that not later than June 15th each school year, the schools report any disciplinary action to the school board of trustees. This is the reporting requirements, this particular section. Subsection B requires the Board of Trustees to consolidate that information and submit it to the Department of Education. Subsection C requires that the Board of Trustees submit it to the department, that the Department of Education submit the information to the Joint Education Committee, summarizing the information provided by the Board of Trustees. So schools report to the districts report to the WDE, and then the WDE reports to you all. 217807 on page 19, beginning on line 4. This is the civil and criminal liability provisions, the legal remedies, a rebuttable presumption. It sort of overlaps with the provisions in 88, and again, the Wyoming Governmental Claims Act and the sovereign immunity provisions are applicable here. Perhaps you'd like to take the same course of action and refer to the Governmental Claims Act. But in subsection A, any school teacher or staff that removes a student in accordance with this act and complies with all of the rules and regulations shall be immune from criminal actions, civil and criminal actions associated with the removal, with the exception of those provisions on page 19, lines 15 through 20. Those include excessive force or cruel and unusual punishment, or when the act maliciously, fraudulently, in bad faith beyond the student's authority. And then again, the staff comment on page 20 is very similar to the comment I already mentioned. I won't belabor that. Page 21, lines 1 through 9. This provides that in any legal or professional disciplinary or employment proceeding involving the classroom management, that there's a rebuttable presumption that the school teacher took the necessary actions to maintain the safety and instruction of the classroom. This language largely reflects the drafting instructions provided, but the committee may wish to clarify what the intent of the language is and the significance of the rebuttable presumption. That's generally a legal term. In this context, I'm not sure what it means. Subsection C, lines 20 through 24. This provides that any disciplinary or employment proceeding consistent with this act shall receive a fair investigation and have the right to legal representation prior to any disciplinary or adverse employment action. And in this provision, and then I think there's a later provision as well, I would note there are statutes that govern discipline of teachers. There are due process provisions, notice provisions, and the disciplinary for initial teachers versus continuing contract teachers is different. And those statutes are actually contained on page 22, 23, and 24, and then on the top of page 25. Additional language created by this act is contained on page 25, lines 12 through 18. This provides that any teacher that takes an action consistent with this bill is not subject to public or professional disciplinary proceedings, reprimand, or negative employment actions. And again, on page 25, lines 22, there are two different competing policy choices in this bill. One is you can't take a disciplinary action against the teacher, period. And the other is the provision that I mentioned earlier on page 21. And so I'm not sure which of those is controlling. They seem to be inconsistent in my mind. Perhaps that can be clarified by the committee or with the input of the Wyoming Education Association. And finally, page 26, line 5, section 2, this act is effective July 1st of 2026. So subject to your questions, I know that's a long bill, 26 pages. Sorry to bore you all with it, but that is my job.
Representative Lawley has a question for you.
Thank you, Madam Chairman. I'm going to go back to page 14 again.
Okay.
I was with you all the way, but this kept bothering me. On page 14, starting on line 17, so section B, and I just am trying to understand how you interpret this. Teachers, comma, with students enrolled in the teacher's class shall create a classroom management plan prior to the commencement of each school year. I mean, what is your interpretation of what that's saying should happen?
Tanya?
Madam Chair, Representative Lawley, I think exactly as you stated it.
Okay.
Teachers with students enrolled in that class must create a classroom management plan prior to the commencement of the school year. And that plan has to be submitted to the various officials, and they need to be approved by the school principal.
Yes, go ahead.
Instructional facilitator that doesn't have classroom students enrolled and is working with other teachers. They are a teacher, but they don't have a classroom management plan, and so they might not need to file it. That would be my interpretation. We can obviously ask WEA, but that was what I was thinking as I was reading it.
Follow
well-
up, Representative?
Yes, please. Again, and maybe if I fill my follow-up might help you, because I don't think that you're getting at what my problem is here. So does this mandate students, prior to the school year starting, meet with teachers to create a plan? And so we're starting with kindergarten on up, it says teachers with students enrolled in the teacher's class shall create a management plan prior to the school year. Again, I'm having trouble understanding that what that practically means, and is there anything in here where we, require students to attend and participate in that? Does this in effect require students to do that?
Tanya?
Madam Chair, Representative Lawley, no, I don't believe so. I think this is an obligation of the teacher. And I think to your point, yes, the classroom teacher would be required to submit the classroom management plan prior to the commencement of the school year, but I don't recall, and candidly, it's very hard to keep these two drafts separate in my mind, but you could pose that question to the Wyoming Department of, the Wyoming Education Association. But yes, I think your interpretation is correct, but I don't see any provision or recall a provision that requires students to be involved in that. I think it's a unilateral obligation of a teacher that has students enrolled. And I also agree with Senator Rothfuss, an instructional facilitator or someone along those lines is not required to do that. And I think that's why the distinction is made with students enrolled in a class. Does that respond to your question?
Follow-up.
Yes, go ahead.
Yes, but I'm still trying to understand how this practically works, as particularly you talk about elementary level. So are students and teachers supposed to participate in some kind of a conversation about this plan? Do they have a ability to weigh in on it? I'm just trying to, what does that say? Because to me, it seems like it's saying the students, the teacher is obligated to get the students prior to the start of the school year together and go over and help create a management plan. Am I just missing what this is saying?
Matt?
Tanya, if I could, I think I could clarify it just a little bit. And I think I even have a fix for it if we stick with that. I think you could just put classroom teachers get rid of with students enrolled in the teacher's class. Almost, I taught in 3 different districts, and they all require a discipline plan. They require each teacher to come up with a discipline plan for their classroom. And each of them might be different. You don't usually sit around and ask input from the kids. You just present that, here's my discipline plan for my classroom. So I think you could just, if you wanted to keep this section in there, you would just add classroom teachers, get rid of the, after the comma, shall create a classroom management plan prior to the commencement of each school year, and I think you'd be fine. I don't know, does that help clarify that?
Well, yeah, because as it's written though here is almost absurd. And I'm sorry, but it's so, that did trouble me of how does this actually work? Especially, I mean, I can even understand somewhat if we were at a higher grade level of getting that interaction, but first of all, requiring it prior to the beginning of the school, all of it. But you're right, we can fix it, but this is what.
Yes.
presented.
Madam Chairman, and Representative, I think you're reading it a different way than it's intended to be read, and I see the ambiguity there. But the with students enrolled in their class is not intended to mean along with. It's a modifier of teachers. So it's teachers shall develop the plan, and the teachers we're referring to are those with students in their class. I think you're reading it, Representative, as teachers along with students in their classroom
Yeah.
shall. That's not how it's written. That's not how I read it. I see how you read it, but that's certainly not the intent. And so it's not ridiculous. It's just that it's ambiguous.
Well, again, what teachers are we paying that don't have students in?
Instructional facilitators, for example.
And this one
Okay.
right here, I'm sorry, but
Yeah.
they say teacher, they use it loosely.
Yeah, they do.
Their
Yeah.
definition of teacher
Okay.
is used
Madam Chairwoman,
Yes, Tanya.
Representative Lally, from a drafting perspective,
Yes,
the commas are very important.
yes,
And so
they are important.
it is
but-
teachers that have students enrolled in the teacher's class shall create, and perhaps that's how you want to fix it, is teachers that have students enrolled in the teacher's class shall create, but the commas are very important in the legal interpretation.
Yes,
That clause modifies teachers. That's not unusual to see in a draft.
okay. Well, it just concerned me about how that would be interpreted and the practical application of our students involved in that. So,
No.
and I think partly she's right about the broad definition of teachers here in the bill. That's how.
Yeah, Madam Chairwoman, that,
ahead, Tanya.
and Representative Lally, that was intentional. I gave that significant amount of thought about how you carve out instructional facilitators or other licensed professionals that may not have students enrolled in a class. And so that's the purpose of the clarifying language is if you have students enrolled in a class, you must have a classroom management plan.
That might have been a better way.
Well,
Right, but again, more clear to me at least. So you're right about the commas though, but I still feel it was confusing, but thank you for clarifying it. But
Other questions? Yes, Senator Scott.
Chairman, question, and it applies to both of the bills. These bills are dealing with the ordinary kind of disruptive behaviors that you encounter. What happens when there is, and what influence do these bills have on the instance where you have some extreme behavior? So you have a high school student who is essentially got the physical strength of an adult, but still a minor, and he's threatening people with a weapon, any kind of weapon, knife or some school, tool or something, or any other kind of weapon, or doing things with fire that are dangerous. And the teacher feels it's an emergency where the bureaucratic processes doesn't work and calls 911, calls the cops. How does what effect do these bills have on that kind of a circumstance? Because Madam Chairman, in this day and age of cell phones, the teacher can pull out a personal cell phone and simply call 911 That's physically very possible. And I would think they might want to do that in an extreme emergency. How does that interplay with the requirements of these bills?
Madam
Sonia, go
Chairwoman,
ahead.
Senator Scott, I would draw your attention to page 4 of or sorry, 14 of this particular bill draft, lines 13 through 15. It provides a permissive ability for teachers. So there's nothing prohibiting a teacher from calling 911. And again, the memo that we provided at the last meeting outlines existing statutes. And I would refer your attention to 21-4-306. And there are a number of items that are grounds for suspension and expulsion. And I don't know that there's a provision in either bill that could be interpreted to prohibit a teacher from taking immediate action to secure the safety of their students and staff. I read this as perhaps dovetailing those obligations, but certainly not prohibited under either provision. And with your reference to possession of a weapon, that's specifically articulated or governed by subsection A, Romanet 5, possession, use, transfer, carrying or selling a deadly weapon as defined by statute within any school bus or within the boundaries of any real property utilized by a district, that is grounds for suspension. And then there's another provision that requires immediate suspension for, oh, here it is, subsection C, requires that the student must be expelled for 1 year on a case-by-case basis if they violate that previous provision that I mentioned. So those students that carry a deadly weapon, 1, they're going to be criminally prosecuted, and 2, the provisions in 21-4-306 specifically contemplate that situation.
Madam Chairman.
Yes, go ahead, follow up.
Okay, I understand that. Let me rephrase the question. Does the procedural requirements of this bill, which involve going through principals and going up the chain and all that sort of thing, does that, if that is not followed in an emergency, does that come back and haunt the teacher?
Madam Chair, Senator Scott, no.
Other questions? Yes, Representative Kelly.
Thank you, Madam Chair. Would it be prudent or redundant to make references to Wyoming whistleblower protections for teachers?
Tanya?
Madam Chair, Representative, that's a great question. And I think it would be prudent to reference them or at least speak to them consistently.
Other questions from the committee? Okay. Follow up? Guess not. Okay, if we don't have any other questions, we'll go ahead and open it up for public comment on these two brave bills. Thank you, that's a lot of work on both of them. Morning, please introduce yourself, even though we've seen those shiny faces before.
And the shiny dome, too, right? Good morning, Madam Chair, committee members, Dickie Shaner and Nate Tajeski from the Wyoming Department of Education. And just here to share some thoughts from Superintendent Degenfelder. And first and foremost, thank you for bringing this topic forward and putting draft bills in front of the committee. As she stated, even back when we were discussing the interim topics during session, this is constantly she gets feedback from teachers about discipline and need for reform. And thank you too to the WEA and the other associations who put a lot of work into this topic. You do have 3 bills in front of you. It's the superintendent's position that in terms of a vehicle for moving this topic forward, Draft 88 probably seems like the best one, just because it's more streamlined than the other ones. But I'll offer some suggestions maybe on some amendments to 88 and possibly bringing some concepts in from 91 into 88. But certainly you're going to hear from other people with different thoughts that I think all worthy of consideration as we move this topic forward. So, Madam Chair, in relation to 88, just looking at the page 2 and then again on page 5, there's reference to State Board of Education rules. We don't think that it's necessary to have the state board actually promulgate rules on this. It doesn't add much to this, and I think less is more when it comes to agency rules. When you get to, so page 2, I think the reference is there, line 18, and then line 19, and then lines 22 and 28. And then on page 5, line 7 has another reference to SBE rules, and page 5, lines 8 to 9 as well, if that's of interest to you. Moving on to page 8, again, this is on draft 88. This one seems challenging as it's written, lines 2 through 6, just because if any employee can request this at any time, it could get pretty logistically challenging for an administrator to deal with those requests, particularly if they were being done in a manner to do that, to cause problems. So there's language in draft 91 that might be more reasonable and comprehensive. That is on, so this would be page 12, lines 15 through 22 from Bill 91, could possibly replace lines 2 through 6 on page 8 of 88. And then also there's some language that could be germane here from draft 91 around allowing for the planning period for teachers every day. That's referenced in 91. And that could be helpful with the demanding schedules we know teachers are facing. But also there's a limitation on that too, that it has to be approved by the administrator if it's not feasible.
Oh, Mr. Shaner, could you mention that again, which one? you're
Yeah,
talking about there?
so on draft 88, delete on page 8, lines 2 through 6, and replace with page 12, lines 15 through 22 from draft 91. And then possibly also look at page 13, lines 14 through 18 in draft 91 for adding in that planning period for teachers.
Yes, go ahead, Representative.
Madam Chairman, question, Mr. Shaner. On that language there on page 13, lines 14 through 18, help me, do I understand that correctly? The word agreement would be struck from the end of that paragraph?
Let's see, Madam Chair, we're looking at draft 91, page 13, lines 14 through 18. I think we would stop the piece that would be moved from 91 into 88 would be lines 14, 15, 16, 17, and then just the word alternative on line 18. That would move. So not anything else on 18 or below.
So agreement is struck. Do I understand that correctly? The last word in that line? That's the
So,
only change?
yeah, thank you, Madam Chair, through you, Representative. That last sentence that reads, if the teacher belongs to a labor association, just not suggesting that move. Just the first sentence, so lines 14, 15, 16, 17, and then the word alternative, period.
Thank you.
Commissioner. Other questions? Yes, go ahead, Senator Rolfus, and then, we'll go to Senator Scott first, and then we'll come back.
Madam Chairman, on the planning period issue, is that going us one step too far in interfering with the ability of local school districts to manage their own affairs? What's the thinking and the key importance of that provision?
Mr. Shaner?
Yeah, Madam Chair, through you, Senator Scott. It could, except for the last clause in there says, unless the school district administration and the teacher agree in writing to an alternative. So it does account for a situation where that's just might not be feasible at that given school. But we've heard time and time again, and I think that it's in this draft bill for the same reason, that the teachers they need the ability to have time to plan, whether it's their discipline plan or whether it's their instructional plans. So codifying that with an exception for administrative alternatives, I think is helpful.
Senator Rothfuss?
Thank you, Madam Chairman. Mr. Shaner, you've gone through the part that I think selects who has the authority to do a lot of this, and it's any school district personnel, and obviously the other draft has a more limited scope in terms of who can do what. And I was curious if the department had any comment on that, because to me that seems like it's a bit of a concern that anyone employed by the school district is effectively treated equally. That doesn't make a lot of sense to me. So what are your thoughts?
Madam Chair, through you, Senator Rothfuss, I added to my pre-prepared list of amendments that Senator Rothfuss's point on refinement of disciplinary authority might be helpful. So I think, yeah, I do think that's a great point. And I think when we're looking at this merging of 91, there's a good language in 91 on that too. So, yeah. Madam Chair, on page 8, lines 8 through 11, so consistent with staff comment, just not sure that that's necessary language. And back on draft 88. And then same with page 9, lines 5 through 8. Consistent with staff comment, not sure that's necessary. On page 10, it might be helpful to add from 91, page 18, lines 9 through 22, and page 19, lines 1 through 2. And that's the data reporting to the WDE and then ultimately to this committee, so that you guys have some information going forward on how this discipline policy is working, what's going on in schools related to discipline. So that's a potential helpful piece from 91 that could go in 88. And then last, Madam Chair, page 11, again, staff comment that there's some inconsistencies and possibly not necessary. But then also, you could look at adding from page 25, lines 12 through 18, from Bill 91. Pull that up here real quick. So, on, let's see, 91, 12 through 18. Potentially, just, and I know there's some legalese in here and some inconsistencies, but I think that the point here in 91 is definitely worth considering and trying to codify, just protecting teachers from acting on this empowerment we're trying to give them. Whatever way LSO suggests that that's the best way to do that, I think is an important component in 91 that should be carried into 88 in one way or another.
Page 11. New section.
And with that, Madam Chair, we're happy to try to answer any questions. Mr. Tedeschi did serve as a principal in schools and has worked on this. And again, we know that there's a lot of opinions, a lot at play here, a lot of questions in terms of how the rubber meets the road with this language. But overall, we think this is great to keep this moving forward.
Questions? Yes, Senator, go ahead.
Page 8, lines 8 through 11, on the referral to the district attorney. You know, I agree you don't need this in order to have that referral made. In some other areas, we have seen difficulties because some district attorneys simply won't act on the referrals. Two questions. One, is that a problem in this area, or have the school districts had good support from the district attorney when needed? And second, if it is a problem, can we give the district attorneys a bit of a push by requiring them, when they get a referral from the school district, to report what action to the school district they have taken and why? Not requiring them to do anything other than report, but focusing a little bit. So is there a problem in this area is the first question.
Go ahead, Mr.
Madam
Chair.
Chair, through you, Senator, great question. We have not heard, just sort of anecdotally, a problem in that regard, but we also haven't really asked either. So it could be something that we could look into and work with, you know, the WSBA and WASA in particular on how their boards and their administrators have been interacting with their county attorneys or their district attorney to see if it is an issue and get back to you on that.
Other questions? Yes, go ahead, Representative Lawley.
Yeah, I appreciate that because again, also is right that the district attorney doesn't need a referral to act, but they do need information. And so I think that's part of the issue, that some of these things are sometimes held closely with the district and they're trying to manage them, and there's maybe even good reason to do that, but there may have been some criminal violations. And so I think that's where, to me, there's a little bit of a, maybe there does need to be some guidance about that, or, but again, it is touchy within each district about, they know their DA, they even know whether, you know, it's really ripe to be reported, but, so they don't need a referral so much as, but where do we give guidance about, you know, what's kept more confidential and that might later impact another child in the district, and what behavior, but might need to be reported, just, you see what I'm saying? It's really, it's not the impediment of the district's attorney's power to act, it's do they have the information in which to make a decision about whether there should be some action on their part. So that I've always felt like that was a little bit of a gap as well, so would like that looked at.
Mr. Shaner, anything on that? Does-
Madam Chair, happy to explore this issue more with districts.
Okay. Any other questions on, yes, Representative Kelly?
Thank you, Madam Chair. On page 18, 217806, reporting, it says, shall report all student disciplinary actions imposed in the preceding school year to the school board, then the school board reports to the department reports then to us. Might it make sense to specify which types of disciplinary actions were taken? I don't see the purpose in massive amounts of reporting of minor infractions, one-time offenses, considering most disciplinary actions never even make it to the administration. How helpful would it be to have very specific definitions of which type of actions should be reported?
And just for clarification, that's on page 18 of 91, Bill 91. Okay, go ahead.
Thank you, Madam Chair. Representative Kelly, good question. The way it's written, we thought it was helpful how the detail gets less each level it goes up. So it starts at, it's very detailed when it goes to the Board of Trustees. Then it's summarized and consolidated when it comes to the department, and then the department will even, you know, synthesize it more for you all. In terms of putting in statute, yeah, maybe in that subsection A, there could be some more district discretion in there instead of all. Maybe it's, yeah, maybe it's, I know we talked about a matrix already, but some sort of list of what the most important discipline actions are, or something along those lines. But I think, yeah, maybe there's some room to to clarify on subsection A.
Follow up, or are you good? Okay. Other questions on either bill? So you probably, hopefully, the good chair and I visited a little bit with the Department of Ed, because again, thinking both of these bills had some good things, and so I appreciate your time, and I tried to go through each bill and replace and add just to see what I thought, and I felt like your changes were pretty good, so. No other questions for the Department of Ed? Okay.
Thank you, Madam
Thanks
Chair.
so much. Appreciate your time. Anyone else? Welcome, good morning, even though we know you. You know the routine.
Good morning, committee. Chairman, my name is Tate Mullen. I'm the Government Relations Director for the Wyoming Education Association. Thank you all for undertaking this. I know there's a lot here and a lot to kind of mix and match, but I really do appreciate the work. I know our educators appreciate the work. This is something that's important to them. I'll just start with some general comments, and then if you all have questions in regards to specifics of 91, happy to answer those. Also have some thoughts on 88. So at the get-go, and let me get to my notes here, sorry. So the intent within our draft was to accomplish a couple of things. First and foremost, provide our educators with some authority, right? The ability to have, and I think that's also reflected in 88, right? Like give our teachers some agency within their classroom, the ability to handle these students. To mandate some administrative support. That was obviously something that we have seen from responses across the state that was important. Again, really giving our teachers voice and agency. That was why we had included them in a couple of those other processes. We know that that was important. And then one of the biggest pieces, and I provided you all with some supplemental material, and it gets to the heart of our discussion around objective, subjective behavior, discipline dialogues, as well as the use of matrices. So the report that I provided you all from the National Education Policy Center, again, we like this work. I want this to be a Wyoming solution. One of the things that I have seen in some of these other states' bill drafts and laws that were passed, they don't address the subjectivity, right? And like what we see when we start just excluding students, when we start expelling them, they disproportionately impact low-income students, students of color. And on top of that, it facilitates what's called the school to prison pipeline, right? And so the cost of addressing those students who are expelled, who statistically have higher negative run-ins with law enforcement, those are costs then to courts, right? Those are costs to programs like CHINS or any of those other remedial programs. And those are long-term higher costs than it is to invest in our students now. So we don't want to exclude and kick folks out for subjective behaviors. And that's hard, right? Because it's one thing if a student brings a weapon, to Senator Scott's point. It's one thing if a student brings a weapon. I can see that. You can see that. That is an objective violation. Now, even the language within ours was subjective. It's hard to get around, right? What is disruptive? What is disruptive in my classroom might not be perceived as disruptive in President Amon's classroom. And we know that our students need consistency. Our students need consistency, our teachers need consistency, and our admin needs consistency. So how do we navigate that? The other supplemental material that I provided to you might actually be something worth considering within the language in 88, whether there's a way to incorporate it. What I've provided you all with is the newly adopted matrix from Laramie County School District #1. Is it a perfect solution? No. But does this help provide some insight into student behaviors? How do we define those? Who's involved in those processes? What does reentry look like? They have tiered these behaviors. They have defined all of those behaviors. They have provided a reentry system. It lays out who has the authority to remove. I think there's a lot of good discussion around both the classroom definition and then who can ultimately remove. But that might be worth some consideration if there's a way to incorporate that. I think these are brilliant. Plus, these also don't completely get rid of the subjectivity, but it also prohibits just this massive expulsion of students that I get really worried about when I see some of these other states' drafts. So again, I'm not, without any prompt, I'm not going to go through our draft. I did have a question for the drafter on 88, and it might be worth some consideration for the what the committee ultimately wants to do. So let me get there. Oh, so we have on page 7, starting at line 17 on 88. This is, again, that requirement for administrative support. I'm curious, and it's something the committee may want to take into consideration for a policy consideration, is what do we do if they weren't given that support, right? Like, what does that look like? I don't have the answer, but I think that's something that might be worthy of discussion from the committee. So with that, I will stand for any questions.
Questions for Mr. Mullen? Yes, go ahead, Senator Scott.
Madam Chairman, this disciplinary matrix that you just passed out from Laramie County School District Number 1, Cheyenne. Madam Chairman, I haven't looked at it obviously in any kind of detail, but it does make sense to me that in a large district, and of course that Cheyenne's our largest, you need to have this kind of detail. You're trying to communicate through a large organization. How do we handle this sort of thing in the districts that are in our smallest third? A Du Bois or a Ten Sleep or some of our smaller districts like that. Ethity. Do you want this kind of a document governing those districts? Or you're talking rural Wyoming is something much simpler going to serve the purpose? How do you handle that, and how do we distinguish in the statute?
Mr. Mullen?
Madam Chairman, Senator Scott, at the end of the day, that's a policy question for you all on how you want to handle that. I would be more prone that if this is something you all think is worth examining in terms of either mandating within 88 or whatever the case may be, it should be consistent. Or if it's just language like we've seen in some of the others, that districts shall adopt or may adopt these types of policies that are just specifically referring to the matrix. Again, I think the consistency is important. So if you were going to do anything involving these matrices, I think it's important that it's across the board.
Other questions? Yes, go ahead, Representative.
Not mine. For a minute, I thought it was, but thank you, Madam Chairman. So I've had a little more coffee, but I'm still hung up on the classroom issue because of just what's not there and what's your view of, so far I've got not restrooms, not lunchrooms, not recess, and not the bus. Now, there may be, and this is a different issue that I'd like LSO to help us out with before the next meeting, which is what's left standing what may become the next bill draft, what's left standing in law, like bus and things, like, so we can see the whole picture. I think that's clear. It's been clear from some of the staff comments that there are these other provisions, and they're not necessarily being repealed. Some may be, but others not. So what do we end up with as sort of this group of different laws concerning discipline or protection of teachers or whatever, like in this realm? So I just like to know, I mean, these areas can be flashpoints. I mean, really, quite frankly, I mean, the classroom can be too, but uniquely so in some of these areas. So what is your thinking about that? Is it not, is it included in the definition? Does the definition should be modified, or is it taken care of somewhere else, or whatever, or none of the above?
Mr. Mullen?
Madam Chairwoman, Representative Lawley, to be frank, I think the definition that Representative and Chairman Andrew provided is a far better definition because it encapsulates all of those other areas that we know are also problematic. So it would be our recommendation that that's the definition to use.
Did you have something, President? Go ahead.
Kim Amon, President of the Wyoming Education Association. I just wanted to piggyback on that. I think, Representative Lowley, that they're not just some flashpoints, they are the flashpoints. As an educator, most discipline issues happen on the playground or in the lunchroom. And that's largely because in the classroom setting, you do have a classroom management plan and you do have that relationship with the students. And so that culture is created to keep those discipline issues down in the classroom. But as soon as they're out of the classroom, there's less supervision on the playground, right? So there definitely needs to be definitions in there that include all of those areas because they are the biggest discipline areas in a school.
Yes, go ahead.
Thank you for that. As a mom and a grandmother, that's been my experience as well, is where things kind of get a little bit of a flashpoint. But so would there be a need then, or do you think the bill already sufficiently has in it some sort of either campus plan or a district plan overall that would cover those areas? Because we have the classroom management plan developed. So does there need to be a plan for those areas as well? I mean, we can expand the definition, that's one thing, but is there already sufficient coverage of those with a plan for the managing the playground and the lunchroom and is there a gap there somewhere? And I haven't absorbed all of these, both of these bills and the different details they have, so maybe there isn't needed, but I would ask you what you think about that.
Go ahead, President.
Chairwoman Schuler and Representative Lawley, I don't know the answer to that for every school district or school, but in my experience, the school usually has a plan for that. There's usually a behavior plan that is school-wide. A lot of times it's a positive behavioral plan and a reward system, and other times there are tiered systems of intervention for behaviors and things like that. So most schools that I'm aware of have that within the school setting.
Other questions? Yeah. Oh, I'm sorry. Did you have follow-up? Okay.
Thank you.
Go ahead.
So, but that's not mandate. So we're creating kind of a plan, like a overarching approach to school discipline. Should it be included, something about that in this, or do we just continue to have districts do whatever they feel they should? And I'm not even saying they aren't doing the right thing. I'm just trying to understand if the goal is something more broad, should it be included here or not? Or is it included somewhere else that we don't know about that, but I'm just trying to understand, because to your point, that these are flashpoints really, and they need as much attention as a classroom in my view. And so, but obviously, so that's, I'm just trying to understand that, so.
Chairwoman Schuler and Representative Lawley, I think that yes, we need to look into that, and we need to make sure that whatever bill we pass includes that, because they are the issues.
Yes, go ahead, Mr. Mullen.
Chairman Schuler, Representative Lawley, I'd like to follow up on that a little bit too, because I think this dovetails into the discussion about who has the authority to take that action, right? This is something we've already heard. And I think that that's worthy of that discussion. So yes, you're potentially looking at a mandated like school plan for those other areas. But I think that there is a dovetail into the discussion about who has the authority to remove, what does that look like?
Yes, let me go to Representative Kelly first, and I'll come back to you. Thanks,
Thank
Representative
you,
Kelly.
Madam Chair. Page 17, on Bill 91, lines 5 through 9. I have some concerns and questions about that. It says, "The interventions in the behavioral plan shall reflect best practices and be age-appropriate and may include providing parental and student support in the form of counseling, home visits, or appropriate classes." So the questions are, first of all, who visits private homes from the state entity, the school? Why are these considered best practices? And what are appropriate classes for parents?
Chairman Schuler, Representative Kelly, great question. I'm glad you asked that because this is something I think we could have fleshed out a little bit better. For those of you that aren't familiar with the community schooling model, what that basically is education is, we know it's a hub, right? So we know it's a hub for our communities. How many discussions have we had where we realized that, for our kids, that's where they spend a lot of their time. And so the things that our students are dealing with on a daily basis don't go away. And that can range from a number of things, right? That can range from food insecurity, homelessness, drug abuse or alcohol abuse within the home, a number of things, right? Those things don't go away when they walk into the classroom. What that community school model looks like is that, yes, the school's goal is to educate our students, but we know that it's difficult to do that when they're addressing all of these other things. This is not a mandate to do that. There's a may include. What we've seen in my experience, I taught in a community school setting where there was basically an agreement between our school and some of the community support systems. There was a food pantry within Access. There were counselors that had access. Home visits was something that was used in Kansas that we saw in terms of infant and maternal care. Just something, again, right, like, how can we provide, and we had this conversation yesterday, how can we provide resources to parents and families and students outside of that school setting, recognizing that those behaviors start there, but then they come into the classroom. So this was essentially a placeholder for us to have that conversation. Is there a way that we can do that we can invest in those support systems for our parents and for our communities?
Yes, follow up, go ahead.
Thank you, Madam Chair. First of all, thank you. I greatly appreciate that we can have these open and civil dialogues when we're clearly coming from different perspectives. I can already hear some of my constituents saying, I do not co-parent with the government. What would you say to those parents?
Mr. Mullen?
Chairman Schuler, Representative Kelly, absolutely, and this isn't it's not a mandate, right? We're not mandating this. This is something that if parents chose to, I'm curious about what resources are available to me as a parent. This is something that simply schools could say, hey, look, we have these resources within our community. We can provide you access to them. We can put you in contact with the folks that run these type of programs to help. So it's not a mandate. It's not the government saying you shall co-parent with me. It's a resource for folks. That's all it is.
Follow up, yes, go ahead.
Just one quick follow-up, sorry, Senator. Thank you, Madam Chair. So would you say then that it's not necessary in statute then if this is something that's voluntary?
Mr. Mullen?
Senator Schuler, Representative Kelly, I would agree. It is not necessary in statute, but is a great opportunity for us to have this conversation. So,
I think Senator Scott and then Senator Rolfes, or do you want to jump? You're good? Okay. Senator Scott.
On this question, we do have in other parts of the state government efforts that do lead to home visitation. Department of Health has a maternal child health visitation program, supposed to be based on the Olds model. Fantastic research where for mothers that are at risk, and at risk being defined as young, poor, and unmarried, you can get a tremendous reduction. And I wish Representative Kelly were here, but tremendous reduction in the level of violent antisocial behavior as the child grows up. And the research evaluated their behavior essentially at the high school level. And it was very striking. And we have been unable to effectively administer that program. So you've got that program, you've got the Department of Family Services, and I think the school people are mandatory reporters if they suspect abuse in the home. Are you seeking to duplicate those programs here in the school setting? What are you trying to do with this language?
Mr. Mullen?
Senator Schuler, or Chairman Schuler, Senator Scott, again, I wanted to use this as a placeholder to have this conversation. I don't want to duplicate those programs. We do have those programs in place. I would like to see us figure out a way to really get those off the ground, to your point, to have them utilized more frequently because of the results that we know that they provide. Basically, think of it as a pass-through, right? Like I recognize that this student has behavioral issues. We know that XYZ community supports are available in our community. Can we put them in? It's a coordinated effort. Can we put them in touch with those resources? Again, to answer my question, answer Representative Kelly's question that dovetails into this, it isn't necessary in statute, but I'm glad we're at least having the conversation.
Other questions? Yes, go ahead, Representative Bratton.
Thank you, Madam Chairwoman. I know in our districts that certainly the principals, they have the ability and they do recommend services, to students or to parents and where they can receive services. So I would consider this duplicative. Thank you.
Would you like to comment on that, President Amon? Go ahead.
Thank you, Chairwoman Schuler. I don't want to comment on that, but I do have a couple of other comments. One of the things that we haven't said yet is that we appreciate the Department of Education's view on both bills, and we also think that Bill 88 is probably a better vehicle for starting and some of the language and incorporating some of the details from the other bill. We fully support that.
Thank you. Anything else? Okay, thank you so much. Appreciate it. Anyone else who would like to testify, please come forward on either bill or both. Welcome, please introduce yourself for the record.
Thank you, Madam Chair. Jeff Jones, Superintendent, Sheridan School District Number 1. Excuse me. In reference to 88, on page 3, and maybe there is a definition for the words discipline and punish somewhere else. I don't see that. But on page 3, line 16, it states, provide all school district employees with the authority to discipline and punish students. I'm not sure what the difference between discipline and punish is, but maybe it is defined somewhere. On page 4, Romanette II, says provide school district employees with the authority to take any of the following actions to ensure the safety of students and the school district employees, and to maintain the opportunity for all students to learn. And then right after that, it says under A, enforce classroom management rules or policies adopted pursuant to this subsection. When I read that, the first thing I thought of is that should be the lead.
when I read every employee has the authority to discipline and punish, I think what the writer of that meant was that they have the authority to enforce the rules. So if you're a coach and somebody's acting out of line, you have the authority to enforce the expectations. That's different than assigning a suspension. And so I would lead with that and eliminate page 3, line 16, that they have the authority to discipline and punish. I believe they have the authority to enforce the rules of the school or the classroom. I think that's common sense. Page 5, line 15. Page 5, line 15, a referral to the school principal, school district superintendent, or the board of trustees for behavioral modification or imposition of the consequences and punishments. When I read that, it seems unnecessary to make a referral if they have the authority, as per line 16 on page 3. That seems, I don't understand how they would need to make the referral if they already have the authority. Again, problematic to have the words punish and discipline for any employee. And then finally, page 6, lines 1 through 10. I don't see where the employee is tasked with making a recommendation, and maybe I missed that, but if you, sorry, I flipped my phone around here. If you read consequences pursuant to subsection of this section, the school principal, the school district superintendent, the board of trustees shall consult with the employee that removed the student to discuss recommended consequences and punishments. So that almost implies that at some point the employee would have needed to recommend consequences. But maybe I'm just reading more into that. And then finally, Madam Chairman, I think, and it's been said before, a lot of, just switching gears to the other bill, a lot of the 26 pages of the other bill seem to be unnecessary, in my view. I believe that it could easily have lots and lots of unintended consequences. And so I don't have a whole lot of problem with 88, other than just a couple of those things that I said. Some of the things that you read through in terms of the potential consequences, frankly, read like a handbook, and I'm not sure are necessary in legislative language. But I guess if there are schools that don't have a discipline matrix, they probably should. I think that's like Education 101, but whether it's in legislation or not isn't going to impact my district unless the legislature says this is the matrix you will use. That becomes a problem.
Questions? Yes, go ahead, Representative Lawley.
Thank you, Madam Chairwoman. Thank you for your comments. They're helpful to kind of, again, somebody on the side that would be using this, it's very helpful. To your last point about things like a matrix and even like model policies, like, is that something, some of these things maybe we don't get so specific on, but again, the district creates some model policies, particularly for my districts are all small rural districts, and creating policies, creating a matrix or being mandated on a matrix isn't all that helpful, but something that the department has looked at and says, look, these are some matrix and they can adopt and take what they want, but it helps them get started. Is that a better approach to you from where you sit?
Yeah.
Go ahead, sir.
Madam Chairman and Representative Lawley, that's exactly what is common from the WDE. I can think of multiple examples where they said, here's an example of a way to approach this topic, and here's some documents that you could potentially use, and some of those we use and some of those we don't need because we have something that already works and fulfills the challenge of what they're trying to assist with. So 100% agree with that. I think the challenge for all of you is if we have school districts that are, and I don't mean this literally, but screaming loudly saying, we need help, we need help. And so you have the balance of how much help do we come forward with from a legislature standpoint versus WDE. And I keep thinking, I want those schools to get help, but when it comes to discipline and 16 pages of, things that we would have to follow to support our teachers, I get concerned that I'm going to spend February to August next year trying to stay out of jail with the policies that we have to create that correlate with the new law. That's what concerns me. So I don't mind guidance, but specific details from a legislative standpoint becomes problematic for a lot of reasons. And so finding that balance, I respect that. I will say, if I were to pick one thing that would be the biggest help, in my opinion, and I don't have the data on this specific point across the state, but the chronic attendance issues that we have are problematic in a lot of ways. First, if you want to talk about dropouts, high linkage to chronic attendance issues. If you want to talk about maximizing student achievement, attendance issues are going to be at the top of that list. And the struggle that we have, we don't have large behavior issues in Sheridan District 1. That's Tongue River and Bighorn. But the students who struggle the most are the ones that are the chronic attendance issues. And it's a small percentage of students, but the problem I have is when I go to the county attorney, and I have as a principal in our district and the superintendent, as a superintendent, the exact phrase I'm told is, we have bigger fish to fry. So I don't have any teeth in the compulsory attendance law. I have none. I have to rely on law enforcement officials to help me with that. But at the end of the day, it's not going to happen, and the parents know that. And so there we are. We're stuck.
Thank you.
Other questions? I'll go with Representative Kelly and then Senator Scott.
Thank you, Madam Chair. Thanks for being here to provide that perspective. My understanding is Sheridan District 1 is a more affluent district compared to some of the ones that we seem to have in mind when we're talking about such legislation here. Maybe some of the issues are not quite as prevalent. So I think what I'm hearing is this district's already on top of these issues, and this could be counterproductive in resulting in more bureaucratic snares, traps, and issues, and cause more problems than it solves, that it's overly prescriptive. And I also agree with some of the language, because language matters. Personally, I'd like to see the word punishment struck out from the entire bill, because having worked with kids, the biggest behavior issues, they're immune to punishment. Their whole life has been punishment. What that word means is retribution. That means making a child suffer for doing the wrong thing or breaking the rules. So I don't like that at all. But I do have a question at the end of all this, and it's pretty simple. What about this bill makes your life easier as an administrator? And what about it makes it more difficult? And what's that balance?
Go ahead.
Madam Chairman and Representative Kelly, thank you for that. I appreciate the perspective that what we're trying to do is meet the needs of all students in our state, but through legislative language, it maybe inadvertently causes struggles for those of us that don't need the help from that specific language. And so if I were to answer your question about what specifically in these two bills helps us out, I would say that we would be better off without either one of them, frankly. That's my perspective. I would love to spend my time working on student achievement and trying to help students fill the gaps in their learning, and less time. I spent 4.5, 5 months in meetings across the state
trying to develop policy that would keep us out of jail around people with firearms in our schools. That was my reality. I've never spent so much time on a topic that has so little to do with student learning. So I would love to be able to focus on student learning with my time preparing for the school year.
Senator Scott?
Madam Chairman, you know, Sheridan 1 is one of the better districts in the state from what I've seen in performance records. And so when Sheridan 1 comes saying, this is the big problem we've got, I think we need to pay attention. And it sounds like the problem you've got is that we might as well not have the compulsory attendance laws on the books because they're not being followed because the local district, I guess it's the county attorney, the prosecuting attorney in Sheridan, just doesn't choose to enforce those laws. What I'm trying to think through is what can we do to get that problem solved? Would giving you the ability to hire a private attorney to seek an injunction against the parents, would that be helpful? Would ability to hire a special prosecutor where there was a dereliction of duty by the district attorney, would that be helpful? Would requiring the local district attorney to give you a report on why he didn't take action on these, would that be helpful? What kinds of, I'm looking for some way where we can get leverage to solve this problem, because Madam Chairman, we enacted, our predecessors enacted compulsory attendance. Good Lord, they've been on the books. I think they were on the books when I was a kid and a student. They're longstanding laws and they're just being vetoed by prosecuting attorney that doesn't think it's important. What can we do in statute that will help you fix that problem?
Madam Chairman and Senator Scott, thank you for the question. A couple things. I don't think the answer is to having stricter punishments for the parents. And ultimately, that is who the compulsory attendance law punishes, is the parent. That doesn't fix the problem of the county attorney saying, we have bigger fish to fry. It wouldn't matter what the punishment is. What I do think the answer is if somebody has an issue with me, there is a formal process in the school board policy that they can go to my bosses, the board of trustees, and make a formal complaint. Who makes the formal complaint in this situation when we have an abuse of the compulsory attendance law, and I go to the local authorities to enforce the law and am told that that's not an option, that we don't have the resources to take care of this? Who do I go to? There should be a formal complaint process to say, hey, this person that's hired to do this job, who's their authority? Because they're the only ones that can hold that person accountable. That's the way I see it.
Follow up, go ahead.
Follow up on that. The local county attorney is an elected official, is he not? And therefore, his boss is the electorate. So getting a public, requiring them to make a public report when they haven't taken action as to why. That's one way to try to get at that. I'm not sure it would be effective. Just get sort of buried and you know, we don't have very active news media in this state anymore. And so I'm looking for some kind of another tool. And maybe ability to take a civil action against them. if you require a report to Department of Family Services that the child's being neglected by not sending them to school, you're probably likely to wind up against the same prosecuting attorney. Madam Chairman, I really think he's pointed out a problem, because we've heard about this from other school districts. And we need to find a general solution. And this, Madam Chairman, this bill would be a potential vehicle for such a solution.
Madam Chairman, if I might quickly respond to Senator Scott. One of the things that might be an avenue, as it stands now, the statute just stipulates that compulsory attendance is required from the ages of the child, but the authority of what constitutes habitual truancy or an attendance problem is defined by the individual school districts through their policy. So in one school district, 10 absences, unexcused absences, might trigger that referral to the county attorney. In another school district, it may not. Well, maybe if there was something, and here again, now I'm going to sound like I'm talking out of both sides of my mouth in terms of, you know, making prescriptive language that now requires, but when we're talking about a law like attendance, I don't know that you would see a lot of pushback schools if we're asking that students get to school, because we can't do our job if they're not there. And so.
Other questions?
Madam Chairman,
Go ahead.
another consideration here, and I've heard complaints against specifically the Cheyenne School District on this score. A number of times, parents of very successful students will want to take the students out of class for a week or two or even three for family trips, sometimes family emergencies, but sometimes just plain family trips, which may be very educational for the student, and they get in trouble with a rigid attendance policy. So we'd have to, I'm trying to figure how do we accommodate that sort of thing, because we could do some harm there too.
Madam
Yes, go
Chairman
ahead.
and Senator Scott, when I have 6 principals in my district, we speak about this very topic. We do not enforce the attendance expectations like we do for students that are very successful in school. And you might say, well, why is that? Why are you inconsistent? Why do you care more about the student who's missed 8 times and is failing their classes versus the student who has missed 8 times and has straight A's? Because the concern that I have is for the student who's not going to get their credit to pass their classes and now becomes on a track to drop out of school. That's a much different issue than the student who's going to Washington, D.C. for a week and a half with his family, has straight A's, and by the way, got a lot of work done prior to even leaving on the trip. I have no issues with those people.
And Madam Chairman,
Yes, go
that's
ahead.
just common sense, but we've got to make sure we don't violate common sense if we do something.
Okay. Other questions? Yes, go ahead, Representative.
Thank you, Madam Chair. This discussion just reminds me, I can appreciate those that are asking for guidance from the legislature, but it comes to mind, this discussion brings to my mind that the more prescriptive our legislation is, the more we cede control from school districts to the legislature. And I believe that's something that we all need to think about. Thank you.
Okay, one more question? Sure, go ahead.
Again, I really appreciate your honesty on these issues, because I think they are important. Some of them we're not really right now dealing with, but I think we will be in the future for some of the reasons you mentioned. But I do want to go back to the draft 88, which you talked about mostly, but a lot of it says may. It doesn't say shall. So it is a kind of guidance without prescribing that you have to do it that way. It's one of the reasons I prefer 88. quite frankly. I think it's more that way. And again, does that ease your mind a little bit more as far as there's very little it's actually saying you must do, but it is kind of providing guidance of what some of these issues, how we could address those in ways that are consistent around the state, if whether they choose to implement or not. But again, small rural districts, and you're one of those actually, but that, helps them along in understanding some things. I just kind of want you to respond to that.
Sure.
'Cause
Go ahead, Superintendent.
Madam Chairman and Representative Lawley, as I said before, I don't have that big of an issue with 88 because it does read like a handbook to me with the word may. If I had, to Representative Kelly's question before, if I had my druthers, I would do away with both of them because I think they're unnecessary. But if we're going to stick with one, I would stick with 88. I would revise the language at the top that says discipline and punish. And I would also just kind of hang my hat on that page 4, Romanette II, this should be your lead, where every staff member has the authority to reinforce the expectations of classroom management if it's in the classroom, school-wide behavior management. Not only is that common sense, but that helps us increase safety in our schools, where if the janitor sees somebody that's bullying another kid, that janitor has the authority to go up and say, hey, that's not okay. We don't treat people like that. And that's our expectation. That's different than punishing and disciplining. So I think just clarity around that, and I really don't have a problem with 88.
Okay, thank you. Appreciate it. Anyone else who would like to testify on either one of these bills, please come forward. Please introduce yourself, even though we saw you yesterday.
Thank you, Chairman Schuler. Chase Christensen, Superintendent, Sheridan County, number 3. More than anything, I wanted to come up and give Senator Scott an opportunity to ask questions. He was speaking to small school districts earlier, and I happen to be representative of the smallest. I did want to just second a lot of what Superintendent Jones had to say. I do think that there's a lot within these bills that is duplicative in nature to what we already have in district policy. I think it's important that we continue to remember that the legislature can pass law, and then the district has to think about what policy it has, and then the schools can think about a handbook and such, and then teachers can build a classroom management policy. But it works in that order, and we need to ensure that we're not building legislation that now gives basically a pathway for that to work in a reverse order, where the teacher would be developing a classroom management plan that then tells the school what to do, that then tells the district what to do. I think that those things just need to make sure they're in place. There is some language within both of these bills that moves a principal's responsibility and what actually statute spells out that only a principal can do, which is suspend students. I think that there's some language there that maybe puts that into any staff member can start to think about that discipline. That's something to contemplate if we want somebody that hasn't necessarily had the training that a principal does, that we go through administrative degree, everything else, and suspending a student is a big action. That's not something to be taken lightly. To attendance, there's not a whole lot better way to say this, but we passed legislation through this body last spring that makes it quite simple. If our county attorneys do choose to support us by pushing an action against a family for compulsory attendance, all that family has to do is come into my office, sit down and say, we are going to now homeschool. And they don't need to do anything beside that. They say we need to homeschool, which again, I don't have a better way to put it, but I think it's just, we've given families permission to not educate their students. And I do think the intent behind both of these bills, I mean, by its very name, Teacher Bill of Rights, is terrific. That we want to, as a body, signify that we are supportive of teachers. I think a resolution from JEIC to the teachers of the state of Wyoming could do a very similar thing, saying that we recognize this is a difficult profession. We recognize that you're doing a hard job, and we support you in doing that. I'm not sure that the bills, as they're written, do much more than that anyway. But with that, I'll stand for questions specifically to Senator Scott with regard to small schools and small districts, if you've got any.
Questions? You're on the spot, Senator Scott.
Madam Chairman, suppose in the course of one of these bills, we did mandate a discipline matrix. What problems would we create for a district your size?
Mr. Christensen?
Senator Scott, I don't think that a mandatory discipline matrix probably creates any different problems for a district of my size than it would for a larger district. Where that falls out is similar to some language within 91, potentially some within 88. There's a call for the people that need to be involved within a plan building meeting or a meeting of that nature. And you spoke to earlier, I may not have access to all of those people. And I think to a further extent there, when we are running into these issues, I think there are, 91 calls for a team that includes the student's parents or guardians, counselor, principal, everything else. Sometimes our students don't have parents and guardians. Sometimes our schools don't have counselors. So when we prescribe the team that has to be put together in order to build a plan that's going to get the student back in a classroom, if we can't pull that team together because we can't find a parent or because we don't have a school counselor, how do we get that kid back in the classroom? I think to your point, the matrix has no issue. It's just if we start to prescribe things that are going to be of their very nature a potential impossibility, we set ourselves up for places where a teacher may have an action against a district or a principal for violating this law when there was no way to follow the law.
Follow up? Yes, go ahead.
Madam Chairman, reinforcing that, working on some earlier legislation that didn't pass, but we were advised that you can mandate inviting the parents to a meeting, but you will have parents that simply will not show up. And you've got to make sure that that doesn't make it impossible to act. So an invitation is one thing, Madam Chairman, but requiring their attendance, which I think 91 bill
does.
did, that doesn't work.
Any other
Just-
questions for Mr. Christensen, or do you want to comment on that?
Yeah, Chairman Schuler, Senator Scott, I think our statutes contemplate and I think rightfully, that the responsibilities and rights of a parent to parent their child in our state are paramount. And we shouldn't be having our schools step in front of that. We shouldn't be having our laws step in front of that, except for in a case where blatantly the child is not being parented. And I think Superintendent Jones spoke very eloquently to the fact that, attendance is one of those places. If we're not getting our kid to school, we're not educating our child, whether it's in a homeschool nature where they're not being educated, or it's in a public school nature where they're not being required to go to school and they're not being educated. Any number of situations, like we should absolutely protect the parental relationship with their kid, but parents need to parent.
Any other questions? Okay, thank you, Superintendent.
Thank you.
Appreciate it. Anyone else who'd like to come forward? Welcome, please introduce yourself.
Thank you, Chair and Committee. My name is Jennifer Hopkins, and I currently serve as a trustee on the Natrona County School Board. I am here speaking for myself today. Public education exists to partner with families, to support parents in educating their children, not to replace them. But what we are seeing here in this draft bill is troubling shift. It crosses the lines between education and government overreach, blurring the roles of teachers, administrators, parents, and even state agencies. The more government tries to take away parental responsibility and authority, the worse the outcome. becomes for the student, teachers, and schools. When we undermine parents, we create division instead of partnership. And unfortunately, this bill, as currently written, risks doing just that. This draft legislation would be granting government and union powers that extend beyond the classroom and into our homes. I think we could all agree on supporting teachers and even a teacher's Bill of Rights, but one that truly supports educators, protects classrooms, and ensures safe learning environments. But this draft, as written, is not that. It should not move forward in its current form. Other states have adopted teacher bills of rights that strengthen classroom support and give teachers the authority and tools they need without crossing into private responsibilities of parents or their homes. Wyoming can do the same. If this idea moves forward, you should work to create a framework that supports our teachers while honoring an essential role and responsibility of parents. I also like to add that I am a homeschooler, I'm a mother of 6, I'm a grandmother of 3. Thank you for your time. I will stand for any questions.
Could you restate your name again? I didn't
Oh,
catch it.
Jennifer Hopkins.
Okay. And were you referring to Bill 88 or Bill 91? The Teacher Bill of Rights, probably, is that the one you were referring to? Okay, I assumed that, so. Questions for Ms. Hopkins? Okay, thank you. Go ahead, please introduce yourself.
My name is Sarah Bieber. I'm a resident here in Natrona County. Your guys' last committee bill in our committee meeting in May, you guys talked about why you wanted to bring legislation for discipline in schools. It's rhetorical, you don't have to answer it, but do any of you feel like either one of these get to that objective, truly? What were we addressing originally? Why were there continued complaints of issues in discipline in school? We aren't able to get to the consequences. I have to agree with Representative Kelly, it's not punishment. It's discipline to focus the child back where we wanted them to be in academics and education and in a learning environment. It wasn't to punish them, it wasn't to take something away from them because they are unresponsive to a certain degree. Do either one of these get that football down the field any farther with that? I don't feel like they do. I agree with the previous speaker from Sheridan that neither one of these helps that goal. What happens if it's not a good faith report? Who decides that? Who gets to decide if it's a good faith report? What if it's not? What if it's retaliation? What if it's punitive? What's the recourse for parents at that point? I'm going to get into the compulsory attendance thing in a minute, but I do think if you do continue down that road, the district attorney isn't pressing the charges. And so it would be beneficial to keep it in there as something, even if it is just reporting what they're not, or what they are doing, or both. For 91, it's 26 pages. Parents are mentioned 8 times. And only 2 of those times does it include them into a process. But it includes them into a process only after something has happened, because they legally have to notify them. I don't think that that's appropriate in any way. It steps on parents. It takes away a whole lot of their responsibility. We just sat here and listened to 2 speakers talk about how parents need to parent. Let them parent. It isn't the school's responsibility to drive in the lane of the parent. So stop driving in the lane of the parent, even at the legislative level. Allow parents to parent, even if you don't like how they parent. Homeschool, pulling a child to homeschool because of attendance doesn't mean that they're not getting educated. That's not a fair example. Parents that homeschool do school their children. They are educated. Compulsory attendance, if you want to fix the issue with compulsory attendance, repeal compulsory attendance. Yes, I understand that that would be massive and big, but if you took away compulsory attendance, then it wouldn't be a thing. And if parents chose not to take their children to school, It's not an issue for the school. You could probably even build it in that if they missed certain amount of days, that they would be expelled. Then it puts it on the parent to figure out how they're going to educate their child. And if they choose to homeschool or they choose to do something different, let the parent parent. Put it back on them to parent. The government saying your kid has to be in school this much time out of the year hasn't worked. It doesn't work. Continuing compulsory attendance obviously creates more problems for districts. That's kind of all I have on it. Thanks.
Any questions? Yes, I'll start with, how about Representative Kelly, and then we'll work down.
Okay, decreasing order of height. Thank you, Ms. Chairman. It was mentioned that it's the parent's job to parent, not the school's job. I concur, but there's also a reality we need to address, that the schools are required by law, constitutionally, to take in kids who essentially are not being parented, who are raising themselves, and teachers do find themselves with undisciplined children who have not had solid role models, who are causing uncontrollable disruptions in the classroom. I think that's what we're looking to address here, the support for the teachers. What do we do when that reality comes into the classroom, that we have a child who has not been taught how to function in society correctly? So considering the insight that had already been given and a clear understanding of the bill and what we're trying to do you have any suggestions for us on how we could support teachers who have to confront that reality that is obviously not the ideal?
Well, you're sitting at a state level. Is it your job or the school's job to legislate parenting? I do understand, but is that the majority of families? Is that the majority of parents? Are the majority of students coming to school not parented, not cared for, is that true? If that truly is where we are, which I don't believe it is at all, then we probably should do something more extreme. But the majority of our students across the state come from two-parent households, come from stable backgrounds with involved parents that are very active in their schools and active in their children's lives. I don't think that picking, even though it is a tragic small minority from the state level, and saying, we're gonna address this and fix this for the few, when you could be negatively impacting the many. It's not beneficial to me from the state level.
Follow up? Go ahead.
Thank you, Madam Chair. Since I was asked a question, to respond to that, the answer is no, it is not the majority. It is a very small minority of kids. However, that very small minority of children cause the majority of issues in the classroom sometimes, and the majority of students, their learning is being affected by that very small amount of kids, and that's a reality teachers are dealing with. So we still need to deal with it, but what I'm hearing is the state legislature is not the way to do it. So to make this practical, because I'm not here to win an argument, I'm here to try and make the best state policy we can. Are there any redeeming qualities you see in either bill? Is there any type of policy, anything that's prescriptive in either of these bills that could support the public school classroom environment?
Speaker?
I think, yes, there is. In 88, being able to give the authority to remove a child from a classroom in those situations, I think that we have moved away from that over the years. I think we have moved away from being able to appropriately apply consequences. You used to be able to, if you caused disruptions, you would go see the coach in the gym and he would make you run around until you about want to fall down. That's a consequence. Like, you just don't do that. We can't do that anymore. It's not, we aren't doing that anymore. So yes, I think there is value in some of it. I don't know that it's state level. it can all be done at the district level, really, but is it being done at the district level enough consistently that all of our school districts are where Sheridan says they are? If our attendance is our biggest problem, then why are we addressing? So I get why it's here. I understand why it's here. And yes, there are some making it cohesive across all districts instead of patchworky. Yeah.
Thank you. Senator Scott, did you still have a question? Or did you?
Chairman,
She
she
answered
answered a number of them, but I would go one step further and say, do you have any concrete suggestions for us? Because we are looking at the circumstance where the majority of kids and their parents are being harmed by a very small minority that is quite disruptive in the classroom. And we need, it's a chronic problem, seems to run across all the school districts. We need to do something about it. What do we need to do?
Ms. Bieber?
I do have some thoughts. There isn't an answer to the problem. That is a problem and a question that we have been dealing with since there have been public schools. There are children that are going to be issues, that are not going to graduate, that are not going to make the grades, that are just not going to. You're not going to get 100%. It's not going to happen. Do we want it to? Yes, absolutely. Do we want to provide the best environment to encourage all of the kids? Absolutely. How do we get there? On a state level, how do we get there? Leave it alone and let the local districts deal with it the best of their ability, because it is a fluid situation a lot of times and it changes year to year. More than that, if we are going to pursue it, I would have to think more about it and get back to you. Senator Scott?
Thank you. Yes, go ahead, Representative.
Thank you, Madam Chair. What I'm hearing is local control's best, but we need protection for the teachers to enforce. That's basically what kind of legislation we need to bring forth, so that the local administrators can do what they need to do without the fear of being sued by the parents.
Well,
go ahead.
Sorry. Thank you. I feel like local control across the state of Wyoming is kind of broken right now, and it's held in the hands of very bureaucratic systems. So it is very difficult as a parent to get within that system and say, I have a problem. I need something to change. I need this thing addressed. There's no accountability to a parent in that. There's no accountability to citizens in a whole lot of the systems out there. So yes, I want to keep it in local control because I don't think it's the lane of you guys to do it. But do I understand that that creates more problems for me as a parent? I absolutely do. But taking it away now means it can't be reverted back later. So I would rather see it kept at the local level. I would like to see our teachers have stronger support from administration and from district staff to support them in their decisions about behavior within the classroom and removing students that are problem issue creating. Yes, I would like to see that. Again, I don't know that that is a state level thing. The superintendents of the districts have the ability and the power to create the policies and administrative regulations to do it right now. So why aren't we doing it? Why isn't it happening? So do we need to have something on the state level that says that they have to support their teachers? Unfortunately, I think we do.
Thank you. I appreciate your testimony.
Thanks.
Anyone else that would like to testify on either bill, please come forward. Welcome. Even though we know you, please introduce yourself.
Madam Chair, I am Brian Farmer with Wyoming School Boards Association. And Madam Chairman, I would like to refer the committee to a packet or information that we provided to you in advance. A survey and some information that we had responded really to your request. Last time we met, I was asked the question, what can this committee do? And I said that I didn't know that because that hadn't been a discussion of our membership. And so we went back to them and we asked them questions. So immediately following the last session, we wanted to put together questions around how student discipline is an issue in the district. To what degree is it an issue? So we asked about things like school climate, instructional time, student safety, staff safety, and teacher and staff retention. How does discipline impact those things? We asked whether or not the district currently had adequate resources to address student behavior issues, and talked about what issues were most prevalent, what student-based issues or challenges were most prevalent in the district, what adult-based challenges were most prevalent in the district. With those two questions specifically, we didn't give them any prompts. We didn't say, pick 3 or pick 5. It was an open-ended question to just really see what their responses were. And Madam Chair, we also looked at legislation that had been passed in other states. This is a topic that has been taken up by a number of states. And so other states had passed a variety of legislation. And so in that sort of question 5, you see some things that had been addressed by other states. And then really asked what the legislature could do to help. And Madam Chair, if you look at question 1, issues related to student discipline are a top focus in our district. Strong majorities agree with that. Our members said, yeah, this is an issue. And when I say our members, I want to back up. I want to say that we made the survey available to all school board members, to all district leaders, so all superintendents, and to school leaders as well, principals. Now, when you asked folks in June to answer a survey, your response is not going to be radically big. We did have 77 respondents from 36 different school districts, so it was representative. We did get a decent number, but folks, are saying, yeah, discipline is an issue. So where is discipline an issue? And at the bottom of page 2, that sort of heat map points out where is this an issue? And issues related to student discipline have a negative impact on instructional time. So discipline is impacting instructional time. Issues related to discipline have a negative impact on student safety. Issues related to discipline have an impact on school climate. Those are areas where we're certainly seeing discipline has an impact. My school district has adequate resources. Again, a majority of folks tend to agree with that. We already have the tools that we need to address behavior for the most part. Then at the bottom of page 3, so what are the issues? What are the disciplinary issues, those student-based challenges? And interestingly, attendance was one of those. The kids that are truant or chronically absent. This has been a discussion that this committee has had over and over through the last several years, talking about that delicate balance between the parental ability to excuse versus the sort of mandate that the child attend school. But disruptive behavior in the classroom being a significant issue. So the child who has that oppositional or defiant behavior in the classroom. Defiance or noncompliance with adult directives. Verbal abuse or threats between students. And again, this is not categories that we asked them to address. This was their responses, and then we sought to create themes based on their open-ended response. So that is really trying to describe that. Now, when we talk about the adult-based challenges, sometimes we find that the ability to work with parents in disciplinary situations can be a challenge. That certainly does not mean that all parents are challenging. Quite the contrary. I would give a statistic, but it would be an entirely made-up one, that a majority of students and a majority of parents are not at issue. We're talking about a small number of students who exhibit these disciplinary behaviors, and from time to time, finding an ability to work with and cooperate with the parent on addressing that issue can be a challenge. A lack of effective alternatives to suspensions, I think, is important because I want to come back to that in talking about what we can do to address behavior. So what resources are school districts using to address discipline? They're using school counselors, they're using SROs or behavioral interventionists, sometimes external resources. And when we talk about, so what is it that the legislature could potentially do, then providing either strengthened laws or even guidance. Sometimes guidance is helpful, and to the point of we don't always need a law to solve every problem. Sometimes just guidance, say from the department or from other resources, can be helpful to allow districts to prohibit students who commit violent acts from returning to the same classroom as the victim. That one's really important because now we're talking about a classroom management strategy of not just dealing with removing the student from the classroom. Strangely, both of these bills, 88 and 91, were mostly talking about removing a kid from the classroom. So we take a kid out of class. Every teacher wants to teach every kid. How do we get that kid back in class? And I don't think either of these bills really talk about that. I don't think either of these bills are really talking about the supports necessary to return that child to class. So where the child has been disruptive to other children, victims of bullying or something like that, how do we address that child? What is the resource for that child? If the child has been difficult, abusive toward a teacher, how do we return that child to a classroom? In some of our Wyoming schools, there isn't another classroom to return that child to. And so that's one of our challenges, is being small, we don't often have options. And I'm not just talking small districts, I mean small as a state. Potential supports would be additional support personnel, additional external folks that we can make referrals or partnerships with, and potentially additional training. And then there's a lot of interesting responses through the rest of the survey. But I think focusing again on how do we get those kiddos back into the classroom? How do we help get those kids where they need to be? And so a lot of schools will look at it as, can that child return to another classroom? Is there ability to get that kid into a different environment where maybe they have a different chance at success? Where possible, I think that alternative is oftentimes used. There are some limited options of removal from the school. The kid who is suspended or expelled, where do they go? How do they continue their education? So there is the possibility of residential placement. A child could come here to Casper and go to Wyoming Behavioral. A child could go to one of the BOCES, to the residential placements at the BOCES. But Madam Chair, there is another alternative that we're seeing a little bit of, and I know the BOCES are really trying to explore, and those are day programs. The kid is no longer in the regular classroom, but they're going to school at a day program where they're able to continue their educational endeavors, get what they need, and then they return home at night. Sometimes that means a kid, say from Douglas, has to drive to Casper to access something like that. And that's less than ideal. We're not necessarily going to be able to have that in every one of our communities, but our BOCES are certainly looking at the possibility of how can we provide those other resources, those other options to students, and provide that pathway that as the student learns to gain better control of their behaviors, that they have that pathway back into the classroom. To Madam Chair, maybe say I'd pause to take questions on that, and maybe a couple of brief comments then on the bills, and maybe suggestions.
Any questions? Yeah, Representative Lawley.
Thank you so much, Madam Chairman. I don't think, I might have missed it because you had a lot of information there, but the idea of alternative high schools, like I know I have a district that created that as a way, and again, a relatively small district, but as a way to place kids in another environment, smaller class sizes and different types of kind of opportunities for them, but out of an environment where they were being kind of disruptive to the ability of other students to learn, which I think is something we often don't talk about enough here, is what about those students where there is disruption? That's what I hear most from my constituents, is honestly the issue of, how their child's experience in public schools being disrupted by behaviors, and teachers are trying to deal with it, but they're told, in some cases, don't send this kid back to the principal's office again. Like, don't do anything. And kids are told to, the other kids are told, bring earbuds or something so you can you can do your actual work in the classroom. So I think there are some other alternatives, but we do have to address both, I agree, but the most what I hear about is what about the kids that are being disrupted every day by a particular behavior, and teachers have been told, don't send them, so by those who did your survey, which I appreciate their position, we want to know everyone's view, but that's what I'm hearing is from parents, and then teachers say, I can't really do much about that. I've been given certain restrictions. So again, I'm trying to match some of these things up, but particularly I wanted to mention the alternate high schools, because I think, at least in our district, it's been an effective way to help that child that is disruptive, and giving them some additional options, so.
Madam Chair, I think that the point is well taken, and to look specifically at the survey certainly does say that the impact to instructional time is the biggest challenge. And so that certainly mirrors what you're saying, is we want to reduce that impact to instructional time, because now that's all kids. It's not just the disruptive child, it's all kids have the capacity to be impacted. And so the question is, what are the options to deal with that? Certainly we can look at student discipline, but we also should look at all of those alternative options, everything from the alternative school to even perhaps just looking at, are there other modes of addressing the child's education? As we move to the RIDE program and some of these opportunities that look at student-centered learning, that does offer something other than a traditional classroom. And maybe a kid who just has a hard time sitting still might thrive in a different type of classroom environment. So all of them should be on the table.
Dr. Brown, did you have something you wanted to comment?
Madam Chair, Representative Lawley, again, I think we would agree with you. As you guys are aware, I've been the superintendent in the largest and smallest district in the state. And in the larger districts, you have the opportunity to even have some transitional or alternative placements at the elementary level. Now, when you're Mr. Christensen and you're in Sheridan 3, you have one teacher for each subject area in the secondary level, and then you have multiple grade levels in your elementary. So it's much more difficult there, and in your economy of scale, it makes it difficult to do that. But I think the opportunity to do that, and possibly having the ability to have assistance with people that will help with behavioral issues within schools, and I think you talked about that at our last meeting a little bit, that there are some things that could happen there that allows administrators to do administrative things such as educational leadership more than doing some of the discipline. But yeah, I do believe that there are some good alternative ways to deal with that. I would say that most districts in the state, even whenever it gets to the top levels, use stipulated agreements for students who are being expelled, and that's probably more than you want me to go into on that. But it's a way of removing kids and allowing them to either go to a virtual school or something else to work through some of those things rather than just being out on the street. So again, I would agree with yourself and Mr. Farmer about trying to have alternative ways to deal with all those. And I'll speak about more issues in a minute.
Go ahead and continue.
Madam Chair, just not to be redundant, I sense a working group coming on. And I would like to ask, as that working group looks at a blend of bills, you know, one of the things that's not necessarily an 88 or 91 is consideration of the special education student. So a kid who has a special ed or a identified behavior that can require a manifestation hearing of whether or not their issue has contributed to the behavior. And there's some other due process things that federal law requires. So hopefully we can add some consideration for the management of somebody that is a special education student in the disciplinary process, at least just not forget it. I don't think that this bill says forget it, but I do think we need to remember that as we consider the process. I think the blending of the bills is a very interesting idea, perhaps an opportunity to bring some things together. I won't repeat any of the things that have been said before, other than to, at the very end of the bill in 81, there's a repealer. And while I think everybody would love to jump on board and say, hey, let's get rid of this immunity for corporal discipline, I think the department's suggestion of there is a piece in 91 that could potentially be blended in that does provide an immunity for appropriate discipline, that would be a good and important piece to have. Frankly, right now, we are relying on this statute in defense cases where they're alleging inappropriate discipline took place. And so this becomes a statutory mechanism to help us defend what one might refer to as, say, an insolent touching. So if Boyd is acting up, and this is going to be funny, if I grab Boyd and I'm going to handle Boyd and I take him outside, yeah, I can't imagine that either. That touching Boyd could be corporal, that is touching the body of the person. And so the removal of him, that in the disciplinary action, it's not the spanking that we think of normally as corporal discipline, but this is the statutory mechanism that we have now. 91 maybe has a better one. So let's not just scratch this one out. Let's keep some type of immunity in there so that in the exercise of reasonable discipline, that if you have to walk somebody out, if you have to break up a fight, if you have to engage in the seclusion and restraint, that there is, when reasonable, some defense for that. With that, I'll be done and pass it along to Dr. Brown.
Okay. Thank you, Dr. Brown.
Madam Chair, again, I just want to kind of go down how, at least I see from being in 3 different districts, how the discipline system works from the state statute to the state rules and regs, comes down to district policies, then administrative rules and regulations at the district level. And then you go down to having a school handbook, a school discipline matrix, whatever you want to call that works there. And then you go into the classroom management plans. Each tier needs to comply with the tier above it. And again, I would say you need to do it at an age-appropriate level, whether you're working with rewards or progressive redirection and discipline. it looks a lot different whenever I'm dealing with a kindergartner than whenever I'm dealing with a senior in high school. They have differing knowledge of where that goes. And I think allowing districts still to work on, maybe you require them to have a matrix, but trying to describe that matrix is very difficult whenever you're trying to deal with 48 different school districts, elementary through high school students. Again, a couple of the things that have already been talked about, I don't want to talk about too much, but as you just heard in testimony, this may cause some problems with the Parents' Bill of Rights. And also, as your staff suggested, it may cause some issues with federal seclusion and restraint rules and regulations. Again, I would suggest that we want to talk about rewards, progressive redirection or discipline, rather than punishment and everything that goes on there. So I would suggest as we move forward that that might be something that we work on. Just touch briefly on the county or district attorneys. I would say in working with them across the state, I don't think there's as much issue if we wind up with a student who is being dangerous. I do think that the issue has always been whether they have the time, ability, and personnel to deal with the attendance issues or the educational neglect. That's what I've heard from most of the districts out there. I'm not going to talk about that because you did. And I guess I would say that I've dealt with staff who have used removing students from their classroom in inappropriate ways. As a high school principal, I had a math teacher. If you didn't bring your pencil to class, they kicked you out of class. Okay, so my solution as a principal, I gave the kid a pencil, sent him back to class. And so trying to think that I've got to get a signature from that teacher to get that kid back in class to learn with just a pencil, I think there has to be give and take there. I've also dealt with administrators who've not done a good job of backing up parents teachers who've had students that have been disruptive in their class. So again, I think it has to be individual, and I think we have to have strong leadership to deal with all that. And you guys passing a law won't change that. It's just like I'll probably drive 81 or 82 miles an hour on the way back to Cheyenne, and I'm only supposed to be able to drive 80. So, but don't tell the highway patrol that.
I think you just did.
Good. So I guess with that, the only other thing that I would talk about is fine collection. And in 88, it talks about not being able to hold a diploma to collect fines. The issue that I see with that is I've seen students with some pretty severe fines for either losing sousaphone, which is probably a $2,000 instrument in the band. And to recapture that, I mean, we find the students and the parents, and we are either going to have to use a collection agency or hold something to be able to get that money back. I've had students who have kept their jerseys from whatever sport they were in because they wanted to keep that too. To be able to replace that, we needed to find them. So there has to be some mechanism for districts to be able to get that back. Now, districts do not hold transcripts. That's statutory that we can't do that, so we send transcripts on, but we do hold that award of a diploma until the fines are paid usually. So I think, and I'm not against not holding the diploma, but there has to be some mechanism to be able to get those fines back for us. And with that, I'd take questions.
Questions for Dr. Brown? Senator Scott?
Madam Chairman, first, Dr. Brown, I would suggest that if he really wants to enhance the Common School Fund, he has to get it up to 91 instead of 81. Seriously, Madam Chairman, question for both the witnesses. We heard a few minutes ago from Sheridan 1, and I hope they'll correct me if I've misunderstood what they're saying. The biggest discipline problem that they're having that is affecting the student learning is failure to comply with the compulsory attendance law, and that they can't get any action out of the local district attorney. If we were to either as an amendment to one of these bills or as a separate standalone bill. Have a bill that really, it's only be a couple sentences long, I think. Say, school district may, and I would emphasize the may, seek an injunction from the district court to compel a parent to cause their child to comply with the school attendance policy. If we were to pass a bill like that, make it clear that they didn't have to go through the district attorney, could use their own attorney, would that be something that would be useful in your judgment, that something that your districts would in fact use on occasion to start dealing with this? Because this isn't the only district we've heard of on this score.
Okay, so I'm going to ask a couple clarifying questions. What I understood you to say was that if the county or district attorney are too busy, don't have the staff, or refuse to be able to enforce truancy or attendance policies, compulsory attendance policies, that we could hire an attorney, or our school district attorney could go forward with an injunction. Is that what is that the question?
Madam Chair, I think the law would be just a general permissive, you can go ahead and do it, you may. But I think the districts would only do that where the local district attorney was being uncooperative, or was frankly saying, look, I've got a bunch of serious criminal cases I got to deal with, and I really don't have time, which from their perspective may well be a rational approach from the district attorney. We still need to have this law complied with. Would the districts welcome a legal ability to go seek an injunction?
Well, I'm going to.
Dr. Brown?
Madam Chair, Senator Scott, I guess what I would say is I don't disagree with where the district and the county attorneys are prioritizing what they need to do. And I think they're probably correct with that. 3 years after I was the superintendent in Laramie 1, I went to court for a case that we had in Laramie 1. So I know that they're stacked up and behind. And with that, I guess I would say, as long as it was permissive, I don't see it as an issue, but I'm not sure. I'm going to turn that over to my legal counsel to see if that's even something that we could do.
Go ahead, Mr. Farmer.
Madam Chair, I think the notion of whether it's helpful or not, perhaps, would it ever be used? I don't think so. Because of the cost in and of itself of doing that, of taking that on. The only district that has in-house counsel at this time is Laramie County School District number 1. Every other school district pays by the hour for the attorney's time. And I think they're taking on that cost would make it unlikely that they would use that.
Okay, thank you. Other questions? Yes, to follow up? Go ahead.
We've heard from one of your school districts, they think that's their major discipline problem. What do we do to address that? We've got a compulsory attendance law. It's not being obeyed. What do we do to address that?
Either one of you want to take that on?
Madam Chair, it is a very complex problem, and I'm sure a complex solution. I think where we have seen it work well is in those counties where there is a collaboration between state agencies and county officials. So when you find DFS involved, where you find the county attorney's office, and frankly, it tends to mean dedication of staff from the county attorney's office. That not just the county attorney himself or herself is going to deal with this occasionally, but that they have staff that are a part of this process, and that the district is involved in this. So it's a commitment of time and resource from all of those agencies. And like other instances where we've looked for the interagency cooperation, I think that's where we have seen success in addressing the problem. So how do we ensure that each of those entities have the staff to address it and then encourage that collaboration?
Any further questions? Yes, go ahead, Representative.
Thank you, Chairman, and thank you, Dr. Brown, for mentioning in passing the virtual classroom regarding that topic of returning a student who's been removed from the classroom to an alternative classroom. In our very rural, isolated districts, we've used the virtual classroom quite successfully. And so I'd just like to reinforce that option.
Anything else? Any other questions? Okay, thank you very much. Is there anyone else in the room that would like to testify on either one of these bills? Well, before I ask for ideas from the committee, I
Madam
would.
Chairman, you
Yes,
do
is there
have-
somebody online?
Yes, you do
Holy
have
smokes.
Patricia McCoy online.
Oh, okay, bring her in.
Okay, I've invited her to join the room.
Hello, can you hear me?
Yes, we can't see you, but we can hear you. Welcome, and please, oh, maybe we can see you. Yeah. Okay, there you are. Welcome, please introduce yourself, and we are running pretty late, so if you could keep it pretty succinct, that would be great. Thanks.
Absolutely, Mr. Chairwoman. I thank you for allowing me to speak today. My name is Patricia McCoy, and I am the chair of Moms for Liberty of Laramie County. Moms for Liberty strongly supports the creation of a meaningful and balanced Teacher Bill of Rights for Wyoming. In fact, our national founders were involved in the development and implementation of the Florida Bill of Rights for teachers, a model that has empowered teachers, created safer classrooms, and respected the critical role parents play in their children's education. We also recognize that Wyoming is not alone in this effort. States like Florida, Louisiana, and Alabama have all passed similar legislation, and others are considering it. What's important to note is that none of those states included provisions that would allow the government or unions to step into a family's home. Not a single one has mandates for parenting classes, forced counseling, or in-home visits tied to school discipline. Those measures are not only unnecessary and unethical, but they would set a troubling precedent here in Wyoming. Back in May, and again recently, we shared with you a draft that aligns closely with Florida's framework. That version protects teachers, gives them the authority and support they need, and ensures safe, orderly classrooms while also preserving parental rights and collaboration between families and schools. It is a balanced and legally sound approach that has been proven effective elsewhere. As you move forward with these discussions, I urge you to consider that our teachers, our students, and our families all do better when we work in partnership. I know that we can create legislation that empowers teachers without compromising the rights and voices of parents. Wyoming deserves a teacher bill of rights that reflects our values and protects our communities, and we are ready and willing to work with you to make that a reality. And I thank you, and I stand for any questions.
Any questions for Ms. McCoy? Okay, I don't see any. Thank you for taking the time to give us some testimony. Appreciate it. Did you say that was Florida that you had worked with? The Florida?
Yes, ma'am. Our bill draft that we sent in May and then again recently via email was aligned with the draft that was enacted in Florida.
Okay, thank you.
Thank you.
Any other testimony? Anybody else online for this bill? Or
No,
either
Madam
one?
Chairman, just Patricia McCoy.
Did you say no? Okay, great. My hearing's going. It's getting close to lunch again, and so I start getting kind of, weirded out. I did have breakfast today, though, so. But anyway, great testimony today, and again, somebody mentioned earlier that maybe we'd be looking for another working group. I don't believe either one of these bills are perfect. I think most of us that I'm hearing probably err towards the side of 88, but obviously I think it needs some work as well. I think the reason that we need to remember this was brought forward is that we were hearing concerns from around the state. I do get into classrooms, not just in my own county and the 3 districts I serve, but other districts in my area in Southwest Wyoming. And obviously there are some issues with discipline. And so supporting those teachers, being able to give them some support. I think one of the surveys that one of the groups did talked about lack of support is probably one of the reasons that we're starting to see teacher shortages. So I think it's kind of important that we do something and not just, we could just leave it alone and say, well, let's go with statute on page 321-4308, punishment and disciplinary measure. It's already in statute. But I think maybe we need a little more to add. And part of that, I think, I started thinking back, I taught in a large school with almost 2,000 students. I taught in a small school with about 400. I finished up teaching in a school of about 900. So I saw big, little, and in between. And as the good superintendents from the smaller districts mentioned, you don't see very many discipline problems in the small schools because we know them all. Every teacher knew the kid, they knew their parents, they knew where they lived. You don't see very many, but when you get into a school district like Casper, Cheyenne, some of these other bigger districts, you see more, you've got more kids and you're gonna have more problems and you're gonna have more issues. And I think, this issue is probably more prevalent in some of our larger schools. But for us to find something, I think, that would fit for everybody, I think is worth taking the time. And even though I'm only gonna be here for one more week, next week, I would be happy to chair a working group if that would be the pleasure of the committee to work on this bill. But again, I'd like to hear what you all think and we can go from there. Thoughts? Yes, Representative Walde?
Thank you. I think that would be great to have a working group, and I think we had some good suggestions, and I would just say I support using 88 as the vehicle because it is very permissive, much more permissive, and there's some other things we avoid that people have talked about being concerned. So I think that we have some good suggestions and I would support that.
Mr. Co-Chair?
Thank you, Madam Chairwoman. To me, this issue seems a little bit less complex and with less questions than some of the other drafts. And I'm wondering if alternatively, something we should consider is adopting the WDE amendment that folds some of 91 into 88, and then looking at the draft individually and bringing final suggestions at the last meeting rather than establishing a fourth working group. I think there's just less variables in this one, and maybe that would be appropriate for this draft.
Okay. Any other thoughts on that? Yes, go ahead, Senator.
Yeah, I don't know exactly what the solution is, and I don't want to necessarily saddle you with a working group either. I think, regrettably, I think both drafts are a long ways from where they need to be, and I don't think 88 is all that permissive. I think there's an awful lot of shalls in 88. There are also a lot of shalls in 91, though, so I think both of them are very top-down prescriptive. I think this comes down to the old adage that we talk about in the legislature: if a problem's worth reacting to, it's worth overreacting to. So here we are writing about 10 times what we probably need. Listening to the public testimony, there were probably two concepts that I heard. One gets down to, what can't a district already do, right? That's a big question. So if a district wants to act appropriately, are there any barriers? And I didn't necessarily hear there were any barriers, with the exception of maybe we have some struggles with specific language around immunity. That's about the only place that I saw a district that wants to do the right thing can't do the right thing. Maybe others heard different, but that's where I was at on that. And then what isn't being done was kind of the next question. And we don't have teachers necessarily empowered in a classroom to feel confident in taking action. That's the only thing I'm left with that isn't being done, that we might want to say, hey, you should do that. I feel like that ends up being around 3 pages instead of 26. And maybe I'm wrong. So I don't know that I would just take WDE recommendations to keep this very large draft. I do think it needs to be taken down to what actually needs to be in state statute that's thoughtfully required to have state law behind it, instead of just recognizing that this is a complicated process that needs districts' involvement. So, that might mean that the best approach is some type of a task force where we actually ask those questions go through the draft and say, all right, well, this is actually necessary at a state level, we need to do this. And again, I would see that as simply adjusting our immunity provisions because they're not great right now, and ensuring that a teacher has the backing to take appropriate action, but without providing necessarily what exactly, all right, under these circumstances, it will be this, under these circumstances, it will be that. That's not us. That's just, that's a district. And these drafts both go into so much detail that if I were, I think, put your cap on as a district trustee at this point in time, do you want to be handed this much? I don't think so. I certainly wouldn't as a district trustee. It would just be one of those headaches from the state legislature, once again, that I have to figure out how to comply with, as opposed to something that's empowering the district, which is, I think, what we kind of heard. There's some kernels in there that would be handy. Let's try and focus on those kernels. So do a working group and get some of those people involved.
Other thoughts? Oops, excuse me. Didn't realize I'd turned my thing off. Other thoughts from the committee?
Madam Chairwoman.
Yes, go ahead.
Madam Chairwoman, I guess I disagree slightly. I mean, in 88, most of the shalls have to do with directing the school board to create policies of their own. I mean, when we get into the details of talking policies, for example, page 5, line 2, all of these policies are prefaced with a may, and it's more of an example. I think I'm just worried that we're going to complicate this issue and add more to it than what I think the goal of this legislation should be, is to back teachers, and to say that school districts shall, I think this should be a shall, back teachers when they need a student removed from their classroom. I think that that is the problem we're trying to solve, and I think that this bill adequately does that. And I think it would be worth moving it forward with that amendment, and then we still have another opportunity to take public testimony and rework some minor details.
Other thoughts? Committee members? Everybody's, Senator Scott?
I want to support Chairman Andrews on this. I think that we can, if we import that amendment that was suggested from the other bill, I think if we remove the words punishment and, where they talk about punishment and discipline, I think if we do that consistently through the bill, and maybe there another amendment or two, we could do it right at this point. I think if we do at least those two things, then we start to 88 isn't ready for prime time yet, but it needs some work to get there. I think carrying it forward with some amendments we make right here and right now is the best way to proceed.
So is that a motion, Senator Scott?
Okay, I'll make it.
Okay, you've made a motion to move the bill, and then we can work on some amendments. Is there a second? Yes, second right here. Okay,
Yeah, and the motion is to move it to the next meeting.
right, move it to the next meeting. Would you like to put those amendments in right now then, or add those amendments?
Madam Chairman, I'll move.
We've got to vote on it, but I mean,
Okay.
let's vote first, or unless
No,
unless there's some discussion. Discussions first? Yeah, go ahead.
Chairman, how do you want to handle this?
Excuse me?
How do you want to handle this?
Well, that's what I'm asking you. Did you want to, we've got a motion to move the bill forward. Do you want to,
Madam Chairman, what I would suggest is you take a trial vote to see if there's enough votes to move it forward. And then
Okay.
if there is, we can do a few.
okay, go ahead.
Madam Chairman, so it seems that the other direction would probably be more appropriate, where folks can suggest their amendments, for example, this amendment, and then once there's a series of amendments, we would decide whether we want to forward that to the next committee meeting.
Procedurally, that's.
Yeah, that's what I would do.
Okay, let's do that. All right. So moving forward, is any more discussion before we?
Madam Chairman?
Yes.
I would move the WDE amendments as written.
Request second, okay.
Give some flexibility to staff.
Yes, any questions on, or any discussion on that, on the WDEs? Thoughts? Okay.
Madam Chairman?
Okay.
If it's friendly, I'd suggest giving some flexibility to staff to accommodate this amendment as is appropriate.
Yes, thank you.
Yes.
I meant to say that.
Yeah,
Good.
I believe you did. All right, if there's no more discussion on that, let's take a vote on that. All those in favor of the WDE's deletions and replacements on 88, please say aye. Aye. All those opposed, no? Okay. Any other amendments? Yes, Senator Scott.
Madam Chairman, on page 1, lines 3 and 4, remove the words punishment and those words before the word discipline, and do that throughout the bill text wherever that sequence occurs. I think we've heard considerable complaint about the using the word punishment, and the word discipline, I think, is a more general word that captures what we're trying to do.
Any discussion on that?
Madam Chairwoman?
Yes, go ahead, Mr. Chair.
So that word was not in the drafting instructions because it's an existing statute. So it wasn't added by anyone to this, and it is, in my understanding, used throughout statute. I think we can certainly remove it, but I just wanted to clarify that.
Tanya, is that correct? We'll ask the experts.
Madam Chairwoman, Chairman Andrew, it is the title, current title of 21-4308, punishment and disciplinary measures. But certainly, if you'd like to remove it, you can. If you look at subsection A, it says reasonable forms of punishment and disciplinary measures. And so is drafted in that way to adhere to existing statute.
Any other discussion on that? So basically, we just take out punishment other than the 21-4308 where it's mentioned right at the beginning of the statute. So all in favor of that? Oh, go ahead. Sure.
Yeah, we can take it out of that, too. I think Senator Scott's motion would basically be to amend statute to remove the words punishment, and
Okay.
it might bring in a few other provisions for cleanup, but it's in order.
Good catch. And Tanya's shaking her head, so I'm guessing that's a yes. Okay, all those in favor, unless there's any other discussion of that amendment, please say aye. Aye. Any opposed? No? Okay, that amendment's passed. Any other amendments? Yes, Representative Williams.
Thank you, Chairman. I believe Superintendent Jones had an amendment that he suggested for page 3, line 16. Is that correct? Was it you that had the suggested amendments? Page 3, line 16, page 4, line 13. Is that correct?
Yes, I had mentioned the part placed under the supervision of an employee by the school principal and designee. And I think what I was referencing is that it implies that the employee has the authority to discipline and punish. And I was making the point that I think what they really do is on page 4, Romanet II, where I don't have it in front of me right now, but my notes were that they're empowered to enforce the classroom rules, the school rules. That's, to me, that makes sense, but that's different than having all employees having the authority to discipline and punish. So I was making the suggestion that that should be removed, that all employees actually have the authority to enforce school rules, classroom rules, as opposed to disciplining and punishing. Because when I think of disciplining and punishing, now you're starting to talk about after-school detentions, in-school suspensions, those types of things. And I don't know that I don't think that's good practice for
every employee to have that authority. Matter of fact, in some cases, it wouldn't be legal.
So Representative Williams, are you thinking about me just scratching out little I altogether? Is that what you're saying? Or I think that's what the superintendent's saying, but
Madam Chairman,
That's
I
your
would
thought?
defer to LSO. Is there a way we can incorporate that amendment, or do we need to, is that premature?
Madam Chair, Representative, so the first amendment you suggested on page 3, line 16, discipline and, will be addressed by Senator Scott's amendment. And I have to be honest, I'm not entirely sure what the intent of the second amendment is on page 4, lines 13 through 17. I do have that marked as an area of concern for Superintendent Jones, but
Superintendent Jones, would you? Chairman,
welcome back. Can you give us some clarity on what your thoughts were?
Thank you. I'm sorry, I don't have a hard copy in front of me, and so I was using my phone before, and I won't take the time to pull it back up. But on page 3, it's what I was referencing was it speaks to all employees have the authority to discipline and punish. And what I was suggesting is that should be removed. And in the amendment would be that it would be, the wording would take up what you see on page 4, double Romanet I, where it gives them the authority to enforce classroom behavior management, school. I don't have that in front of me, but that's what it was referencing. To me, that makes sense, that all employees would have the authority to reinforce classroom, school, building rules. But that's different than what's listed on page 3, stating that all employees have the authority to discipline and punish. That was the point I was making.
Yep, go ahead, Representative.
thank you, Madam Chairman, and I appreciate that, and I would like to move that amendment if that language is
Basically,
clear.
you would just delete I, little I? Is that basically what you're saying, Representative Williams?
Yes.
Little I on page 3, just eliminate the entire paragraph. And so little I2 would be the beginning of that. Does that make sense? I think that's what you're saying. I could be wrong.
Madam Chairwoman, I would note that school district property is defined in Romanet 1 as well. What might be an appropriate suggestion is for me to work with Superintendent Jones to operationalize what his concern is. That could potentially be your motion, Representative Williams.
So moved.
Okay, great. Super. Thank you so much. Appreciate it. I had a couple of ideas for wordsmithing, but I prefer Tanya's wordsmithing over mine, so on that. Other amendments? Yes, Senator Scott? No, we didn't. Let's vote on that. All those in favor of Representative Williams, did you have some discussion? No, okay. All those in favor of Representative Williams' amendment on page 3, please say aye. Aye. Any opposed? No? Okay, that amendment's passed. Yes. Go ahead, Senator Scott.
On page 9, there's a staff comment regarding the sentence that is on, right above there on lines 5 through 8, with regard to the Governmental Claims Act. Madam Chairman, I move that we direct the attorneys to fix that problem by modifying the language in the draft so that there is a reference to the Sovereign Immunity Act, making it clear that the Sovereign Immunity Act is what is governing, but alerting everybody that that does provide immunity in this case. I think I don't want to try to do the drafting work right now, but I think that's something that can be fixed, and the staff comment is well taken here, but the way to fix it is with a cross-reference.
Did we?
So people reading the education code know that immunity is there.
Go ahead, co-chair. I'll let you mention that.
Madam Chairwoman, that part was deleted with the WDE amendment that we added to this bill.
Other amendments? Yeah, Senator?
Is that the only sovereign immunity one? This bill, or is there another one?
Madam
Andy,
Chair,
do you know?
Senator Scott, that is the provision that addressed civil and criminal liability, and it was deleted by the WDE amendment, lines 5 through 8, beginning with any.
Okay. Madam,
Yes, go ahead, Senator.
I've lost track of what was in which bill. Is that the only reference in this bill to the sovereign immunity issue?
Madam Chair, Senator Scott, yes.
Thank you. Other amendments? Other ideas or amendments? Okay. Well, with that, I guess we just need a motion. Oh, your motion. It's already there, isn't it? We need to vote. Yes, we need a roll call.
No.
Nope, we don't. We just
Not
need.
final action.
That's not final. Okay. Let's go ahead with a motion on the bill then. All those in favor of the bill in its present form with various amendments and other things be moved to the next meeting in November, I believe, with the proper amendments in there so we can take a look at them. Please say aye. Aye. Opposed? No? Okay. That amendment is passed. Excuse me, that motion is passed. And I guess yes, Senator Scott?
Madam Chairman. Related issue. Is there any enthusiasm on the committee, and I'm good part asking the chairman, to try to deal with the attendance problem? I think a simple bill that I gave a few minutes ago, a suggestion, I would add to the suggestion, I think probably going to have an appropriation to the State Department of Education to have a fund source where they could assist districts that were needing to do it. Is that something we want to undertake? It's related to this, but I don't think it would be I think we could put it in this bill, but I don't think we ought to.
Committee, what are your thoughts on the compulsory education, compulsory attendance, excuse me? Senator Kelly?
Thank you, Madam Chair. I'd be interested in entertaining it, but I don't think Senator Scott would be interested in the direction I would like to go, as I favor repealing compulsory attendance. So I don't think we would be on the same page and we'd move anywhere.
Any other ideas? Yes.
Yeah, I'd probably end up where Representative Kelly was also on that one, more than the direction Senator Scott. But I just think we have a lot of work already for next time. I think we added 2 additional drafts, adding in another additional draft. This one has taken us all morning, so probably not a lot of time left.
I guess the other thing then, at this point, we had a lunch break. Well, we actually had a break listed, but that was some time ago.
I took it.
You took a break, hopefully. We have 2 more bill drafts to take a look at. I guess I'll just leave it up to the committee to give me your ideas on, do you want to go ahead and take the lunch break, or do you want to keep powering through and get these 2 done? We have 0089, K through 12 public school disciplinary policies and procedures, and then we have 26 LSO 0090, the K through 12 categorical grant to assist in student success. So should we take a break, or how about if we just do a vote? Those that would like to power through, raise your hand. Okay, 5 of us.
No, the last time we did that was like 3 o'clock.
It's probably going to be past that anyway. Those that would like to go ahead and take a lunch break, raise your hand. 1, 2, 3, 4, 5, 6. Okay, looks like we'll take a lunch break. So, yeah, can we take a quick one? Can we be back by 1? That doesn't give us a lot of time. All right, we'll make it 1:10. 1:10, be back. All right. Yes. Is the office quick?